national monuments that had been designated since 1996 that were over 100,000 acres. There are political reasons that the executive order was written that way. 1996 was the year that Grand Staircase Escalante was designated by President Clinton. It's been controversial ever since that designation, so 21 years for an executive order review seems weird until you realize that that was the year that that happened, and then it makes perfect sense. And the impetus for this is complex, and it's a complex issue, but I think a lot of it stems from the mineral withdrawal issue. None of those lands are available for oil and gas leasing. The state of Utah in particular has been pretty opposed to any kind of land protection on federal public land. And Rob Bishop, who is currently the chair of the House Natural Resources Committee, has been urging this kind of review for a long time, and has also been urging to either get rid of the Antiquities Act completely or to alter it so that presidents can't designate national monuments by themselves. And so there were 27 national monuments that fell into that category, including R2 here in New Mexico, which I hope everybody has visited, and if not, go visit them. And so Zinke was supposed to have that recommendation out by August 24th. It was leaked to the Washington Post sort of in tiny little pieces. And there were recommended boundary changes to some national monuments. Fortunately, ours were not included in those boundary change recommendations as far as we knew. And then the full report actually just came out. And so there were huge boundary changes recommended to Bears Ears and Grand Siskiyou, and also to Gold Butte and Grand Staircase. And then there were other monuments that had recommended management changes. And so those management changes seem to be geared towards ensuring that certain uses can still happen in the remaining monuments, even if they stay the same size. And there were recommended management changes to both of our monuments. So far, Trump, a couple of days ago, did sign an executive order shrinking Bears Ears and Grand Staircase. And so that has been done, but that was so far the only action that he's taken on any of those recommendations. So for us, we're still sort of in a holding pattern because we can't really do anything until Trump does something. Like for now, it's just Zinke saying that this is what should happen, and Trump hasn't done it yet. And I should point out that Trump can do, I mean, I don't think he can actually do whatever he wants, but he does do whatever he wants. And so he doesn't have to listen to Zinke's recommendations. You know, he could change our boundaries through executive order, and then we'll have to see what happens. But for now, nothing has actually happened to our monuments, which is great. I did kind of want to just go through sort of the history of legal action surrounding the Antiquities Act. I put a lot of this in the materials that you guys have, so we don't have to go through it too much. But you know, this act was passed in 1906, and since then, there have actually been no challenges in court to a president's authority to shrink a monument. So there is no case law about that. I'm sure there will be soon, because people have already filed lawsuits about Bears Ears and Grand Staircase. There have been presidents who have shrunk national monuments. One in particular was really large. It was in the 20s. There have been other small boundary adjustments made by executive order, but none of those were ever challenged in court. And so the only legal authority we have to go on is the act itself, which does not grant a president the authority to undesignate, and a couple of attorney general's opinions which also say that the president has no authority to undesignate. And the reason for that is because of the way Congress delegates authority to presidents in general. And so when you compare the Antiquities Act to other acts that give the president authority to make executive actions, this one is different because it specifically gives him the authority to designate and doesn't say anything about undesignating. And so that's going to be something that's going to come up in these upcoming cases. Hopefully it'll go the way it should. The other thing I will note is that in 1976, Congress passed the Federal Land Management and Policy Act, which is the organic act for the Bureau of Land Management. And in that act, it said that only Congress could modify national monument withdrawals, which are like, you know, withdrawals from a certain use is what they meant. And since 1976, there have been no attempts to modify any national monuments. So all the attempts to modify national monuments were before FLTMA was passed. And once FLTMA was passed, kind of codifying the authority of Congress to change monuments, this has not even been attempted. And certainly a review like this has never been attempted. So it's pretty unprecedented territory where we are. President Trump seems to think that this is uncontroversial, but I don't know how he got that. But during their public comment period that they held during this National Monument Review, they got millions and millions and millions of public comments from Americans, which is awesome, and 99% of them asked the Trump administration to leave all the monuments exactly the way they are, including in places like Utah and New Mexico. 95% of New Mexicans' comments asked for the same thing. New Mexico actually had the highest per capita comment rate of anybody else in the country, so way to go. And so it is controversial. There have been protests. There's going to be lawsuits. I have no idea what's going to happen, but hopefully it will be okay. I think that's my overview.
Thank you. And I encourage you to look at the materials. Judy submitted a 20-odd page comment to the Interior Department that really goes in detail, and I find quite interesting. I skimmed it. I read the parts that look important. All right. Jack, we originally thought a discussion of Garrett's Desert Inn might be interesting for those of you who haven't followed it. This was the motel that the State Land Office got in trade for the Dixon Apple Orchard, and then put out an RFP for redevelopment, and there was some significant concern in town about how things like historic regulation would be dealt with. In the end, it didn't turn out to be such a big issue, but it seemed like a good jumping off place to maybe talk about the State Land Office's approach to local regulation. So I'm interested to hear that.
Okay, so as Chris suggested, there's some controversy in terms of the topic being public lands. It's a terminology that is somewhat disfavored at the State Land Office, notwithstanding the title of the position of the commissioner being the Commissioner of Public Lands, which is a statewide elected position. The preferred terminology at the State Land Office is trust lands or state trust lands, because the lands were granted by the federal government essentially at statehood in trust to generate support for specifically designated beneficiaries, primarily public schools. Each piece of state trust land has a designated beneficiary, and all proceeds from leasing or selling that land are to go to that beneficiary and nowhere else, really. There's a holdback from the renewable leasing revenue to run the land office, but we are otherwise, and the state as a whole is prohibited from using those funds for any other purpose. And so, and the lands are not open to public use. I think the resistance to the term public lands is largely a concern about a perception that the lands are open to public use when they're not, and there are specific trespass and depredation statutes as it relates to state trust land. The total grant of land was about 13 million acres, and it took some time to get all of that acreage into state ownership. We have what are called numbered school sections, and 4 sections in each township being basically granted for public schools. If for some reason we didn't get those 4 sections in a particular township, we could make what we call lieu land selection, and so there were quantity selections there. And then there were grants, quantity grants for particular purposes, the School for the Blind and the penitentiary for university purposes, things like that. And those were selections that were made by the land office over the decades. And so what you have is dispersion of state trust lands all across the state, some of which are in a checkerboard pattern and some of which are consolidated. And for the most part, those lands are not located within municipal boundaries. Some are, but we're mainly focused on things like grazing leases and oil and gas leases that are not within municipal boundaries. And over 95% of the revenue that comes in to the State Land Office is related to oil and gas leases. And the obligation under the Enabling Act is to get true value for any lease, easement, or other conveyance. And so and there are restrictions on how conveyances can be made. Some of which come into play in terms of how something like leasing the property that we acquired in downtown Santa Fe would go, and how you would apply some of the law as it relates to capital outlay projects in a context like that, and I'll get to that in a sec. One of the things to note in that regard is that the terms of the trust prohibit us from using any of the proceeds from state trust land to make improvements on state trust land. So if anybody is going to make improvements, which are often necessary to achieve the highest and best use of the land, those improvements are going to be made by somebody that we issue a lease to. The State Land Office doesn't use any of the trust money to do that, and for the most part the legislature has not appropriated general funds to do that sort of thing. In terms of municipal regulation, there's the somewhat well-known Pump Jack case from 1981, where the land commissioner put what was substantially larger than the existing pump jack that's out in front of the building up.
It's down at the State Fair if anyone wants to go see it.
Seeing the photographs in the paper when the things came up with regard to Garrett's and seeing how big it was, I was a little bit stunned. And then I did have the pleasure of going to the State Fair for the first time this year and surprisingly stumbling on the original pump jack that was out in front of the building. The issue in the case was whether the city of Santa Fe could apply its historic design ordinance to have the pump jack removed. And what the court said was, for the most part, and the general rule is that a municipality has no authority to regulate the use of state land absent a specific delegation of that authority from the legislature. There are some issues in the case in terms of what exactly the Historic District Act did as far as giving authorization, but in terms of the specific case in front of them, they decided that the existing Santa Fe Historic District Ordinance could not be applied to have the pump jack removed. In 2009, the Historic District Act was amended to provide a specific process for applying municipal historic district ordinances to state capital outlay projects. And it provides a particular mode of doing things. And what it says, among other things, is that ordinances enacted by a municipality or county pursuant to the Historic District and Landmark Act shall apply to a state capital outlay project only as provided in the section, and only if ordinances contain special provisions and standards applicable to state buildings, including provisions concerning the design, construction, alteration, or demolition of the exterior features of state buildings. If requested by a resolution of the governing body of a municipality or county, the staff of the Capital Buildings Planning Commission shall work jointly with the staff of the municipality or county in developing the provisions and standards required by this law. That's very hard to apply to the leasing process that we follow, particularly where we're doing a long-term lease that may provide for redevelopment of the property. Because we're not in control of that, we really just issue a ground lease, and the lessee is in control. You know, it has a permitted use, but we don't design the improvement. We have some authority to approve or disapprove things, but we don't engage in a process that really fits with the capital outlay project process. So in 2016, we acquired the Garrett's Desert Inn property, as Chris said, in a land exchange with Coche de Pueblo. And we acquired it subject to a lease that expired at the end of August of 2017. And we've done a lease that allows the current operator to continue to operate the property through the end of 2017. And in the meantime, we've been going through a process to issue a new lease, and we're getting to the end of that process now. We've conducted a lease auction, and we're soon to be, if not today, probably very soon, executing a lease with somebody who's going to come in and take over the property at the beginning of the year. It's expected that that lessee will use the existing structures rather than redeveloping the property. But as part of the process of reviewing the bids, the commissioner put together a committee that included representatives from the city, a representative of a historic preservation group, and an architect experienced with the historic district ordinance to review. And ultimately, we got two bids, one of which provided for somewhat more extensive renovation of the building, but not really a full redevelopment of the property. The winning bidder really seems to be anticipating very minor modifications to the structure while very substantially renovating the interior parts of the motel property. As to whether the bite will stay or not, I think that's an open issue. That seems to be the biggest concern that anybody has about what's going on over there, other than the possibility of a Trump Tower Santa Fe going up over there. But so that's kind of how that looks right now. There was a bill introduced in the last legislative session. So in the session this year, at the beginning of 2017, a bill was introduced that would have modified the Historic District Act to give municipalities full authority to impose historic district ordinances on state land, regardless of whether it involved the capital outlay project. We went up to say that's very difficult to really work with the kind of leasing process that we have. The bill passed, but then was vetoed by the governor. And so this process that we've gone through with the Garrett's Desert Inn property was without that kind of legislation, but with some open issues in terms of how the current ordinance would apply to that property. I think the way things are playing out, that those things are going to be largely moot at the end of the day. I wanted to say a couple of other things about municipal regulation and how the land office deals with land that we have within municipal boundaries, or where counties have an interest. We have an instrument that was used a lot in previous administrations, but not so much in the current administration. It's something we call a planning and development lease, and what it is we lease where it seems like redevelopment is a thing, whether for residential or some kind of commercial activity, is what the land is suitable for, but it hasn't really been. The planning and development hasn't been done. We can lease it to somebody. That lessee does planning and development work, and at the end of the day, if we do a long-term lease or we sell the property, that lessee is entitled to a share of the increase in value that results from that activity. So it's a way of having a lessee or a private party doing that kind of work that has a lot more ability to do it. We don't have planners. And for the most part haven't over the years, and really don't have a lot of capacity to do that kind of work. And so this is an instrument that allows us to realize the value that may exist in a particular location without having to do that work. And so, for example, the Mesa del Sol property down in Albuquerque is one that was under a planning and development lease, and a fair amount of work was done under that to work out that particular development. We're doing a takeout sale right now. It's called Paseo Gateway. It's near Rio Rancho. And so there was a party that did various planning and development on the state land that's basically adjacent to where the Cleveland High School is, which actually used to be state land. And so we're doing some work to sell some of that, and then that lessee will continue to work on the surrounding property. And eventually, I think what's anticipated is that we'll end up disposing of that. When we dispose of land, we're mostly just selling the surface. We're required to reserve the mineral rights, and so we have a lot of the original 13 million acres. There's 9 million surface acres left. That means we have 4 million acres of split estate minerals, where we own the minerals, but somebody else owns the surface, and so we run into issues as it relates to that. One final thing to note. As it relates to some of this land where there's local concerns as it relates to the practice during the Powell administration was to do things that were called joint planning agreements, which were really just MOUs between the commissioner and a county or a municipality that would provide essentially a consultation process. And it really stated a commitment that if the state land was going to be developed or redeveloped, that there would be consultation with the local governing body as to how that was going to go and what that might entail. Those were terminated at the beginning of Commissioner Dunn's administration, and we'll see what, in terms of somebody new coming in 2019, whether that's something that somebody picks up. But it is the kind of thing that's been done in the past to take into account local concerns as it relates to development or redevelopment of state trust land. And just one other point in terms of the monuments. There is state land that's within the monument areas, and it's been a big concern over a long period of time of us getting landlocked within those kinds of designated areas. The comments that we submitted as it relates to the Rio Grande del Norte and the Organ Mountains monuments was really just to advocate for completion of exchanges that would get us out, give those lands put those lands into federal ownership and management, and get us something that they have that better suits our mission. We have a signed agreement to complete that kind of transaction as it relates to the Rio Grande del Norte monument. We were trying to get a similar kind of thing for the Organ Mountains monument, but really haven't been able to do that. But we're very optimistic of being able to complete that transaction by the end of Commissioner Dunn's term at the end of next year.
Yeah, and Judy, I was going to say, your organization had supported that effort as well.
Yeah, so I was going to say the conservation community in general supported that very much. You know, it works out better for everybody if there aren't little inholdings of state land inside a monument or wilderness area or whatever, because the federal land has the designation, but the state land doesn't. And so the state land can't do what it wants to do with that land because it can't get to it sometimes, or it can't add roads, or it can't whatever. And so it benefits everybody to have a unit sort of managed as one thing. And then the Bureau of Land Management actually does keep a list of what they call disposal lands. And so those are acres that they already know that they can't use or don't want, and so those are often lands that are used for exchanges like that. And so, yeah, it was a big collaborative effort that we hope gets finished. So,
going back to the pump jack case, you know, as lawyers in private practice will tell you, and probably lawyers in government practice also, you know, on a regular basis, a client or prospective client will come into your office and say, you know, I want to pursue this, and it's the principle that's involved. And, you know, I think we all have a talk that in some way discusses how expensive principles can be and how difficult they are to completely vindicate. But an anecdote worth adding in the pump jack case is that immediately after the court issued its opinion, that pump jack was removed and sent down to the state fair. So it, at least at the end, became very much an issue of what the state land office's ability or obligation was, as opposed to anything having to do with the pump jack itself. Jack, I had a question, though. You know, I'm interested in the discretion the commissioner has, or how much room you have to maneuver between, on the one hand, your obligation, I don't know if it's statutory or constitutional, to maximize revenues, and the other hand, a willingness to work with local concerns or local regulation. You had talked about the Trump Tower going in at Garrett's Desert Inn. Say you had a third applicant who responded to your request for proposals, who intended a 20-story hotel there that would unquestionably maximize revenues for the state land office. What discretion does the commissioner have to say that would put us in a really bad position, and we'll go with number two?
Well, I think there are a couple of different approaches to that. One is for us to say something in the lease that would govern that, and as part of the lease auction. So I don't think that the law could be applied to say that we couldn't state specifically in the lease certain restrictions that we would impose that we felt were appropriate as far as being a responsible landowner, responsive to community concerns on a site that's clearly of historic significance. The other part of that would be that in terms of approving anything that somebody wants to do, the commissioner generally reserves the right in a lease to approve what happens is in the way of building or modifying improvements. And so he would have some discretion there. In terms of the leasing process itself, the fact that we go through a lease auction doesn't mean that we have to complete that process. I mean, we could redo it if we felt like what we were getting at the end of the day was not something that was consistent with what we thought was in the long-term interest of the state land office and being a responsible landowner and that sort of thing. And so while we're obligated, if we conduct a lease auction, to give the lease to the highest and best bidder, we have some ability to manage that process so that we're not just obligated to do a deal with somebody who we don't think is going to be an appropriate lessee who's managing and redeveloping the property in a responsible way.
Thank you. I think you'd given me an example when we talked about freshwater use on Ogallala being the commissioner deciding that while you could get some revenue from that, it wasn't necessarily an appropriate use of the fresh water.
Yeah, I mean, those are different kinds of instruments. What we do, and there's a lot of this going on in the southeast as part of the oil and gas development there, is we issue easements that allow people to put water wells on the state trust land for purposes of drawn out water that they can, for example, sell for fracking and things like that. We have pending litigation regarding one where we didn't impose any kind of restriction in the easement itself, but the commissioner ultimately was trying to implement a policy that really was trying to put an end to taking fresh water out of the Ogallala aquifer when it was being used for that purpose. We've now got a policy where we're doing this kind of stuff on the front end, but we don't auction those off. I mean, we have a rate schedule for doing that kind of stuff, and so that he has a lot more discretion in terms of what kind of instrument he's issuing, what those terms and conditions are, and when we're going to do it and when we're not going to do it. It's when we get into an auction process that we're really, if we're going to do anything at all, we really have to be going with what the high bid is. And we don't really, that's a different process for issuing those kinds of instruments.
Okay, thank you. So let's move on to Tim to talk about public use of land.
Okay, thank you. Again, I'm Tim Rogers, Trails Program Manager for the Santa Fe Conservation Trust, and some of my colleagues at the Trust presented at last year's conference and on the conservation easement work that we do, and so I would like to do a quick overview of what that work is, and then what the Trails program specifically does, and then touch on a few of the legal issues around developing trails, specifically New Mexico's recreational use statute, and also touch on prescriptive easements for trails. So a little background. We are a land trust, and we hold conservation easements on land, on private land, so that that land does not get developed. That's where the trust, we're actually celebrating our 25th year in next year. And I'll just read our mission statement. The Santa Fe Conservation Trust is dedicated to preserving the spirit of place among the communities of northern New Mexico by protecting open spaces and critical wildlife habitat, by creating trails, and by protecting the traditional landscapes of our diverse cultures. So it really, the land program is the centerpiece. We've gotten involved in trails all along as public, a form of public access to our conservation easements. It's not required, but especially we have so many easements around Santa Fe and inhabited areas where there's demand for trails, and so we try to include public access. We've also focused on preserving night skies. The land program, and these are a couple slides that my colleagues wanted to show last year, and I understand there were AV problems last year, and so I'm happy to be able to show this. This one has a timer on it, so it keeps changing on me. I'll just have to keep pushing it back, but this is from their presentation, and updated, that we have 83 conservation easements on over 36,000 acres in northern New Mexico. We work in Santa Fe County, Rio Arriba County, San Miguel County, and Mora County, and we have certain focal areas that are circled on the map: Santa Fe and Tesuque, Galisteo Basin, Upper Pecos, Las Vegas, Piedra Lumbre, which is Abiquiu, and Los Pinos, which is northern Rio Arriba County. So as I'm the Trails Program Manager, full-time position since 2014. We've had Trails Program Managers in the past. It wasn't quite full-time, and my position was created thanks to a contract we've had with the city since 2014. As I mentioned, trails have been part of the conservation work and even the conservation easement work of the trust since its inception 25 years ago, as a way to create public access to open space, working both with private landowners and the city, county, public agencies. We are increasingly involved in maintenance, especially, and construction of trails. It started with work relating to our conservation easements. We've worked with the county from the beginning with the rail trail, for example, all the way up to more recently the La Piedra Trail. We've had a city contract since 2014 under which I'm responsible for organizing trail volunteers to maintain city trails, natural surface trails, the Dale Ball trails, La Tierra trails, and others. And it also involves promotion of the trails and as well as planning for the trails, and that's a pleasure to be involved with. I'm certainly a trail user, and it's great to focus on that for my work. We also adopted the Atalaya Trail, which is a national forest trail adjacent to the Dale Ball trails. And if you don't know the story of Dale Ball, you know, he worked to preserve open space and public access in the East Foothills, and that's how we got the Dale Ball trails. He was one of the founders of the Santa Fe Conservation Trust. The work I do in the area of promotion includes a big focus is field trips to city trails, and since 2014 we've taken over 1,500 kids out to Dale Ball trails and La Tierra trails, primarily from schools on the south side, Nino Otero School and Camino Real Academy. We're working with partners on a new initiative that so far we're calling the Prescription Trails Collaborative. It's really working with public health partners to promote the use of trails in the city as healthy exercise. We've been involved in planning with our partners over the 25 years, and lately that's embodied in what we're calling GUSTO, the Grand Unified Santa Fe Trails Organization, which is a community-based planning effort to connect all of the wonderful natural surface trails that we have around the city. This is kind of a conceptual map that shows a lot of the natural trails as well as the paved trails that we are working to connect, and with just a circle, which is kind of the GUSTO vision. So in order to get our public partners and our private partners on board, we need to talk about the benefits of trails, and really there's three major areas. We first got involved because it is conservation work, so the trails serve an environmental purpose to expose the public to the open spaces and get people to really value what we have and understand what it is. As I mentioned, there's a real public health angle on trails, both physical activity as well as exposure to nature. So it's really all elements of public health, from chronic diseases to mental health and even spiritual health, if you will. And then finally, the economic value of trails. And certainly trails in Santa Fe are playing a role in our economy, and they're an attraction for people to visit Santa Fe, to live in Santa Fe. And they also have been shown, people are often reluctant to, they don't want a trail in their backyard, just like they don't want things in their backyards. But really trails have been shown to, and one of the reasons is a fear that your property values will go down. I don't know if that's a real omnipresent fear anymore. It was in the past. And there's an organization called Headwaters Economics that's produced a lot of materials around open space and trails, and particularly to help organizations like ourselves that are trying to work to develop these resources. And they've shown that, they've gathered research showing that trails, in fact, will increase property values. And they've got a few examples. My favorite examples for the Santa Fe setting are some examples from Texas, of course. And in San Antonio and Austin, they provide information showing that trails really have a specific measurable premium on the value of real estate. And they also can play a significant role in tax revenue so that public agencies can build and maintain trails. Segging into legal issues, Headwater Economics also created this paper, Legal Issues Associated with Trails, an introduction. It's for lay people. I think lawyers probably also could benefit from a quick read. It's 8 pages. It really focuses on particularly liability and risks and how to limit the risk. And so that's important because when we're, especially with the Gusto initiative, we're looking at trying to connect trails that are in public open space, and what is between the public open space is private land. And so we do have easements in some cases on private land, but there will always be a need to reassure private landowners that they're not undertaking an undue risk by allowing trails, formal or informal, on their land. So they provide a review of recreational use statutes, which they point out grant limited liability to landowners who permit access for recreational purposes. There's statutes in every state. They're intended to make it possible for private landowners to allow this desirable activity without taking on risks. So I'll read you a synopsis, and I apologize I didn't provide this in materials ahead of time, but the gist of New Mexico's recreational use statute is any owner, leasee, or person in control of lands who grants permission to any person or group to use the lands for purpose of recreational use does not thereby assume any greater responsibility, duty of care, or liability to such person or group than if such permission had not been granted and such person or group were trespassers. So in other words, there's not a higher duty than the duty that exists to trespassers, and which is a fairly low level of duty that I'll get into in a second. You can see in this synopsis there's some dots there. There's some material that's left out, and that probably should be concerned to anyone who's trying to get to the deeper meaning of this. And so here's really the full language, and it specifies that this is in cases without charge or any other consideration other than consideration paid to the landowner by a public agency. And then it specifies types of recreational uses, but then says any other recreational use. And that by doing that, you're not extending any assurances that the premises are safe. You're not assuming any duty to care to keep such lands safe for entry or use. You're not assuming responsibility or liability for any injury or damage to or caused by such person or group. And as I mentioned before, you're not assuming any greater responsibility, duty of care, or liability to such person or group than if permission had not been granted and the person or group were trespassers. I want to acknowledge actually a former board member of ours and Trails Committee member, Tom Simons, who helped pull together some of this research over the years, particularly as a member of our Trails Committee. So that was all under A. Under B, it just says this does not apply if it's in exchange for consideration. So what is the duty to a trespasser? This is some very small type that's hard for you guys to read, I'm sure, but this is something Tom Simons dug up. It's the Uniform Jury Instructions on Duty to Trespasser in New Mexico. And so it differentiates between a landowner's duty for natural conditions versus artificial conditions. And so natural conditions and a trail that's just in a natural setting, an owner or occupant of land has no liability to a trespasser injured on his or her land from a natural condition of that land. So a trail like the one in the photo that's dirt, rocks, trees, really there's a pretty limited level of risk involved for the landowner. I guess the real risk is someone could try to sue you, but they're not likely to have success suing you if they slip on these rocks or trip on a tree limb or a root. And so really, in discussion with folks in the legal community, nobody has come up with a case where somebody has been successfully sued for having a dirt trail that someone was injured on. If you know of a case, we'd be interested to hear. So artificial condition on the premises is a different story. There is a duty to a trespasser. If the owner or occupant creates or maintains an artificial condition on the land, then he or she has a duty to a trespasser to use ordinary care to warn of the condition and of the risk involved. And it does continue, but I just wanted to show a picture of an artificial condition and what a particular landowner has done to point out that it is an artificial condition. And it says, notice to hikers, you're invited to hike on this trail and use this bridge at your own risk. And in fact, on the bridge, there's a little sign right there. It says, Old Bridge, use at your own risk. So users are put on notice that there is an artificial condition that perhaps could be a hazard. And then, so it does talk about the duty to use ordinary care to warn of the condition if the condition involves an unreasonable risk of death or bodily harm, and that should be reasonably known by the landowner, and the landowner has reason to believe that the trespasser will not discover the condition or realize the risk involved. The owner-occupant owes no duty to make his or her land safe for a trespasser unless and until he or she knows or reasonably should know that the trespasser is on his or her land. So really this kind of signage if you have an artificial condition and you know that it could be posing a risk to people that you can reasonably foresee are using your land and on a trail in your land, whether there's an easement or not, by notifying folks, you can limit your risk. So one way that that it's been thought, oh, well, maybe I can transfer the risk to a public agency. And so in some cases, this is an example of an easement for a trail that was granted by a private subdivision to the city of Santa Fe. The reality is the city of Santa Fe is now also a party, also an owner in a way of this trail. But ultimately, public agencies, as you know, have their own protection from tort liability, and the private landowner is still the landowner. So not much has changed in terms of would a person try to sue. But again, I think the probability of winning a suit under, as described before, is low. So switching gears, some of those cases were cases where there was an actual easement on the land. In other cases, there was no actual easement, but it was use of private land for a social trail, informal trail, you could say. Another concern of private landowners, if there's not an easement, but they are allowing use, can that easement turn into a formal, or can that trail turn into a formal easement for a trail through a prescriptive easement? And the answer is not very likely. There's a very high threshold. There was a case, Algermissen versus Sutton, in 2002, focused on the Bosque area in Albuquerque, and local community members were not successful in trying to create a prescriptive easement on a dirt trail they had used to access the river, the Rio Grande, for years. And they were not able to satisfy the court that all elements were in place. The use of land must be adverse, must be known, open, or notorious, 10 years without interruption. It's very difficult to create a formal trail easement through a prescriptive easement. But if it is a concern, if you have, or you're allowing people to use your land as a trail, and you don't want it to develop into a prescriptive easement, the easiest way is to give people permission, because then it's no longer adverse. And so just a couple signs showing that your private property, on the bottom, permission for access may be withdrawn at any time. So that satisfies that. And as long as you're putting up signs, you can add rules that you may have for the use of your land. Be quiet, no littering, dogs on a leash. Here's another one that just says you invited to use this as long as you know the owners of this tract may change or abolish its use at any time. So prescriptive easement would not be formed. Seeing all these signs, I like to see signs that provide, instead of telling people where not to go, I think it's easier to tell people where to go when that's the situation, when that's the concern. This is just an example of a trail on public land, and they don't want people going into the house. They're providing useful information that trail users will use. The trailhead is over there to the left, not in the house's backyard. And finally, I just wanted to show one sign, more of an urban trail, but it's private land. And initially, a homeowners association manager felt that they needed to block access to this trail And so their recommendation was to put up a no trespassing sign, and not to the pleasure of the walking and bicycling community, but they felt that that was needed to protect themselves from possible liability. And I know a lot of the people who live there were not happy with a no trespassing sign, and I was very happy to see a few months later the no trespassing sign was taken down, and just a nice message was replaced it. This is a private neighborhood. Please respect our area. Keep it clean and quiet. That's great. I love to see that kind of sign rather than a no trespassing sign. So that's a quick overview. If you have questions, please feel free to follow up with me, or we can talk now too. Thank you.
And I was happy to see that sign changed, because I used to feel a little bit guilty going through there constantly, as I did. Are there any questions? I think we were a little bit tight on time, but if anyone can address them.
Not seeing any. It is 2:30, so it's time for the next panel. So
I'd like to thank the panel, and thank you all for coming.
Our next panel is Economic Development and Community Involvement. It's right away, so we don't have a break here, but you will have a break right after this. I'd like to just take this opportunity to say two things. Here, I'll stand in front of the camera as I've been instructed. One is that please be aware that the break after this is the time period in which the State Bar Association will be present to sign people up if you're doing the trust and accounting. So please be vigilant, get out there, sign up. It's a special requirement, and we'll deal with that at the break. And the other comment I had was that we do have evaluation forms. If you didn't get one when you came in, please get one and fill it out before you leave. I know some people are taking some credits and not other credits. We're very interested in your feedback, so please do an evaluation for whatever portion of the program you're attending. And with that, I'll ask that the next panelist assemble and come on up. The staircase is on the other side if people want to use stairs. Yeah.
I don't care what the order is. Mr. Weber. Okay. My name is Frank Katz. I am a member of the board of the Neighborhood Law Center.
Goodbye, everybody.
No, they're just getting snacks. They're getting reinforcements. The focus of this panel is really going to be on the relationship of the individual and neighborhood to the city government. Sometimes city government decisions can seem like an assertion of greater wisdom, and that's not always taken so well, and perhaps the soda tax is a little bit of an example of that. But I think that's not true. I think it's often an assertion of a wider view by the city government. They are aware of things that affect the whole city. As an individual, of course, I'm concerned about my block. And as a neighborhood, I am concerned about protecting its character. As a city, however, we have a bit of a wider view. Take workforce housing, for example. Please take it. The city knows we need it, but the neighborhoods don't want to take it. And much of my experience as city attorney, working on the H Board, working with the Neighborhood Law Center, Neighborhood Network, and Old Santa Fe Association, is a lot of focus on we don't want this in our backyard, whatever this might be. And I think what we need is a process that recognizes the wider view and insists that the needs of the city are indeed shared with all of the neighborhoods of the city. The trick, of course, is to find a process that includes citizen involvement, and hopefully that will lead to their buy-in. Matt Brown sitting in the middle there, is the city's economic development director, and he brings a fascinating experience he had in California with participatory budgeting in San Jose, California, and the wise ways of using games to encourage citizen input and indeed buy-in. Alexandra Ladd, to my immediate right, is the city's affordable housing leader, and she will recount the problems we've faced in obtaining workforce housing that's so crucial to economic development in the city, and talk about how fair share housing approach helps turn NIMBY into YIMBY. Maybe it should be HIMBY, how in my backyard, or WIMBY, where in my backyard, just as long as it's not in my backyard. Alan Weber on the far right there will call on his experience with urban issues in Portland, Oregon, and with how entrepreneurial economy works from his time at Fast Company magazine. And he will outline suggestions on how to make citizens the center of the city government's focus. So let's start with Matt, if we may.
Oh, sure. Hey, everybody. Okay, confession one, I'm an ex-lawyer. So you can come join me if anyone wants to quit now. I'm ready. I can give you a lot of pointers. Okay, so two topics wrapped in one. So participatory budgeting and then gameplay or game theory. The general principles around participatory budgeting is a way in which citizens and city officials work collaboratively and work together to establish the operating budget for a city. And you can think of this sort of conceptually as, imagine we're all sitting around tables together, actually talking to each other and having a dialogue, and it's an enriching dialogue that's getting us better informed and enabling us to make better decisions, as opposed to a typical structure that we often see, which would be citizens coming to, or residents coming to a podium, having a minute or two to declare their point of view and then stepping down. So that's not a dialogue, that's not a conversation. So one foundational aspect about participatory budgeting is how do you create the conditions for a constructive, healthy dialogue that then results in outcomes that the majority of people can support. Now, there's different tools and techniques for doing this. The one that I'm familiar with and the one I highly advocate for is something called serious games. So these are, it's a type of technique for using to achieve participatory budgeting. But this technique is built around game theory. And I won't bore you with all of the aspects of game theory, but game theory, when people play games, a couple of key things is it engages people in thinking more creatively than they might normally, and also more tactically. So it lets you generate ideas and then converge down onto winning ideas. But it has a neurological effect. When you play games, you open yourself up in ways that you wouldn't normally. Right? Games also have very specific rules and abilities to make the playing more fair and equitable for everyone who's participating. Okay? So if you're just having a conversation, you might have someone who's very strong-willed and maybe even loud can dominate the conversation, but a game normalizes all that, takes that kind of ability away and makes everyone equal players, which is great, right? Because we want everyone to have an equal voice, equal engagement. And those are sort of two of many, but two big benefits of playing games. To give a quick example, the city of San Jose, I think they're now in their 6th year or 7th year of using a game called a budgeting game from a company called Contenio. And imagine at City Hall, they have tables set out, and about 150 to 200 citizens pile around these tables. And all of the city officials are there. The mayor, the fire chief, the police chief, they're all there. And in preparation, they've gone out to the community, all the neighborhoods, and they've asked people, what do you want? Right? Do you want a new school? Do you want the potholes fixed? So that's all been collected in advance, and money has been allocated. The actual cost for doing any one of those improvements has been allocated. So now when you sit down to play the game, I'm like the banker at the table. We have 8 citizens, and we now have all of the things everyone wants and what it actually costs. But the problem we all face is whatever everyone wants is more than we have, right? So if we have $1 billion of wants, but we have a $500 million budget, we need to prioritize. So what we do is you take the money that's actually the total budget and you give equal amounts to all the players. And then you play the game. I got money. I want a school, I buy that school, right? But what happens is that very quickly, many things you can't buy on your own. So now you actually have to negotiate with other residents. And we pile our money together. And you keep buying the things that you want. And until the game's over, I can actually go to the banker and I can get the money back because Alan convinces me that that school is more important than the fire department. So give me my money back. The fire department's no longer purchased, but I'm going to go in with Alan. Now we're going to buy a school. Once all the money's spent, okay, you do that with all the tables and you aggregate all that information together. And when you're done, what you spent your money on is what is your operating budget. And those games can be played in person and they can be played online. So you can literally have every single citizen, or every single resident, play those games. Right? And the nature of this, why it's called a serious game, is because you're using real dollars. You're using real information. So when you play the game, you solve the problem. Right? You're not playing a game trying to learn strategy and then deploy strategy in some other scenario. It's not scenario planning. This is problem solving. So that gives you a little example of how serious games work in practice in real life every year in San Jose and many other cities and organizations across the world. Oh, yeah, interesting. So Alan reminded me, and it's a subtle twist. If that budget needs to go get approved, but there was another, so that's one scenario. Another scenario is this game has also been played to determine what citizens and residents might be willing to be taxed on. Okay? So go out, play this game, you're like, oh, looks like we're willing to be taxed on a school bond. Right? When that's been done, 6 to 8 months later, when that bond comes up for vote, the average vote is around 72 to 74% in favor. Right? So you do this work, okay, and the results are high level of support, because it's highly collaborative. The other thing about it is a little bit of the neurology of it too, is when you play with the pretend money, right, and you go, I buy it, it's done. You've already done it. If you come back and ask someone 6 months later, do you want to buy it? You're like, I did that 6 months ago. Of course I want it then. I still want it now. Right? So it has a cementing effect when you play games this way. You are really making earnest, real choices in the moment that you're playing the game. It's not abstract. It's quite concrete. So there you go.
Okay, thank you. That sounds very exciting. Alexandra has a harder problem.
Oh, mine was easy.
She deals, yeah, that's just, play money, right? Why don't you talk about some of the problems that we have faced with dealing with workforce housing and getting it done?
Thanks, Frank. Now's the wet blanket part of the talk. So I am the director of the Office of Affordable Housing for the City of Santa Fe, and I have actually had the honor of being part of this conference before, so if some of you have heard me and have heard all of this, I apologize in advance, but I do want to make a couple of points today. I think one thing that I constantly am trying to remind people is that when we talk about affordable housing, it's hard. I think people instantly have an image of what that means in their heads. It means something, slightly substandard, not as nice quality. Oh, the people living there probably have problems. Maybe there's more crime. And I want everyone here to just wipe that image out of your heads, because here in Santa Fe, and I would think this is the case in many communities, we have people fully employed with 1 full-time job, 2 jobs, 3 jobs, working their butts off, and they are our workforce but they are not who anyone thinks of when we talk about workforce housing. Our electeds like to talk about workforce housing because that sounds more productive and sort of more economically, developmentally appropriate. That's you, Matt.
Okay.
And they're picturing the teacher and the firefighter and maybe the young person who's going to work at Descartes Labs, et cetera, et cetera. But I want all of you, the next time you're at a coffee shop or you're at the grocery store, or you're at the gym, and you look around you, those people in the workforce, probably half of them are cost burdened with their housing costs. And so coming back to the city's efforts to provide housing, we look at it in terms of it's this interrelationship between funding and policy and regulation. We have an inclusionary zoning program here, and we're one of the few communities in the nation that does. We're very proactive with our funding. We've built the capacity of our nonprofits to an amazing degree, certainly the best in our state, probably some of the best in the country. And real estate development, and that's perhaps where we run into the biggest interaction, shall we say, with neighbors and with property owners is when we look at actually creating the units on the ground. And so I think I want to make that one point, if you remember nothing else I've said, that there is no silver bullet, that any successful effort requires a combination of all of these tools. And I also want to say that we can't just meet the needs of one part of the housing ecosystem. So if we're really, really good at training home buyers, and we're really, really proactive at funneling funding for down payment assistance, and we work closely with developers to make sure a percentage of units are affordably priced in their new owner-occupied projects, and we do all of this, that's awesome, super important. But if we don't also have affordable rental housing, some of it maybe even with high support services, if our renters are cost burdened, they're getting into debt, they're ruining their credit, they're never going to become homeowners. And for some, obviously, that's not the right option. I don't want to advocate homeownership's the only option, but my point is that we can't do one part of it really, really well and not take into consideration the rest of it. So the city has, over the years, developed an approach to housing along with all these multi-tools that we try to use, but also to really look at the entire spectrum of housing need. So those are two things. And then I'll say one more thing before I pass it on to Alan. And I think we also, as a panelist, when we were talking about this before we got up here, we do really want to hear from you guys. So I hope we can have some more discussion as well. But my final point, and this is kind of where the city-neighborhood interaction comes in, would be for anyone, and I'm sure several in this room, who are parents for youngest children or grandparents to youngest children. You know, when you ask the question, okay, are you ready to get dressed? It's time to go to school. And for a young child who has no sort of control over their outcome, or very little control, what's the only answer they can give you that gives them any control over that outcome? No. Even if they like school, even if they like the pink striped socks you picked out for them, no, that's the only way they can control what's going to happen. So I feel like too often we put neighbors in that position of feeling like, oh my gosh, the only way I can control this outcome is to say no and to stick with the status quo. So I would love to hear from all of you, how can we have that conversation in a way that is productive, where we can arrive at yes, and we can arrive at let's make it better, and we can arrive at solutions that meet the needs not only of new residents served by new construction, but existing residents who will welcome the new construction into their neighborhoods.
Thank you.
Okay, Alan, a couple of things. One is the answer to Alexandra's question there. How can we help neighborhoods get that involvement early. And another thing is, how important is this housing to economic development? Is there some relationship there, perhaps?
Thank you, Frank, for putting that on my plate. Thanks for being here. I was here last year, and I really enjoyed it. In fact, I liked that panel better. Can we do that one again? You were my moderator last year. We had a much easier topic. This year, Frank, you've really given us the giant load to work with. I want to try to make a few quick points. I'm not sure I'm going to answer your question, but I think, to your point, we have time for more open discussion. I think while this is framed about housing and framed to be about housing and neighborhood interaction, I think there's a bigger question that lies at the heart of the conversation, and that is when you think about the interaction between the city, citizens, people who live here, residents, businesses, developers, neighborhoods, what's the point of the exercise? What are we trying to achieve? And I think housing is one output, but that's not really the point of the exercise. The point of the exercise is to have a city where people feel that their voices are heard, that the system respects them, that we really are a community that can work constructively toward outcomes that everybody shares in. So what we're really talking about is a political process question with the presumption that if we create a process that works fairly, equitably, openly, transparently for people all over the community, we will arrive at outcomes that we will all feel better about than we have recently. And affordable housing is one issue, but we've had others recently. And so Matt's example is essentially a process approach. If you were to take that and reverse engineer it, and you were to say, how do you design a system to fail? You would design the system we've got, particularly in the case of housing. What you would do is you would have all of the housing projects be done as essentially one-off activities. You find a piece of land, you find a developer, or the city has a piece of land and proposes that it be developed, and you put that out there, and then you ask the neighborhoods, how do you feel about that specific project? And the answer is, we are being told what to do, and we are being picked on. Why are you selecting us to be the victim of this process? Why don't you take that project somewhere else? Why is it developer-led? What's the hidden agenda? You give us a report. We have to respond to the facts in the report. We don't get to actually participate in the creation of the project or the parts that go around the project, the parts where you're not just building a housing project, you're creating a neighborhood. That's not the context. The context is one project at a time, up or down, adversarial proceeding. And so if you were trying to design a system to fail, this is the system you would design. And surprise, surprise, it works brilliantly. It works just the way it's designed. Every proceeding is adversarial. The neighborhoods are essentially put in the position of being against something, and they perform their role brilliantly. I want to quickly offer a couple of options, and then we can open it up for conversation. About 40 years ago, I lived in Portland, Oregon, and my wife, Frances, was a neighborhood planner and architect. There was a piece of property in Portland called Sauvie Island. Sauvie Island is a beautiful island that is situated at the confluence of the Columbia and Willamette rivers. And historically, it was an island used for farming with some houseboats, very low density, beautiful bucolic neighborhood. A developer proposed housing for Sauvie Island, and the city took on the job of essentially describing in planning terms Matt's idea for budgeting or tax issues. Frances and her team of planners went out to Sauvie Island, and rather than calling for a hearing, which is a lot like a focus group where the loudest voices always prevail, they produced a very carefully designed questionnaire that went to every resident on Sauvie Island individually to their home, asking a set of questions, in effect doing what Matt described. Early data development opinions of each landowner or resident in a houseboat or property owner asking a set of very specific questions. What would you like to see for this? What would make you happy if it were developed for housing? What would you like it to see if it weren't developed for housing? That data came back, was collated, and turned into a second round of questionnaire work. By the time the project came before the Planning Commission and then the City Council, it had essentially been negotiated into a consensus agreement. Much of it was done without adversarialism. It was done by private conversations through questionnaires arrived at with respect and mutual input, not a one-shot hearing where you're either for it or against it. That model suggests there are many different ways to create a system that is not designed to fail, a process where people's voices can be heard, data is actually, and input is actually sourced, and you end up with a very different conversation. It's a strategic conversation, not a project-based conversation. Second example, I've been doing some work previously with the city manager of Gainesville, Florida. In Gainesville, Florida, a couple years ago, the then mayor asked the head of economic development, to Frank's point about the merger of housing and jobs, how could we make Gainesville more competitive? And what the economic development director, now the city manager, came up with as a solution was he wants to make Gainesville the most user-friendly city in America. So imagine, you have paper in front of you. Here's a little thought experiment. Draw a picture of city government on your piece of paper. Come on, do it. It's not going to hurt you. It's not a trick. It's not a tax. I'm not going to tax you for doing it. Just do it. What does it look like? I mean, most people will draw, I'll give you the preferred answer, most people will draw a pyramid-like structure. Here's a mayor or the equivalent of a mayor, here's a city council, here are departments. They all function as the city government. And then you ask people, now where on that chart are you? And the answer is, I'm standing over here, this little stick figure over here, looking at city government. Now my friend Anthony said, what if we redraw that? So that instead of city government being this pyramid with the citizens over here and the residents and the businesses and the developers and the neighborhoods looking at it from afar, you designed it as an entrepreneurial interaction, a service-based interaction. So the individual is now in the middle and the city is a circle around that individual. And the services are organized to make it as easy as possible for people to get the outcomes they want, to do the things they want to do. So that you end up with a very different mindset about what the city's services are organized to do. One very simple example. In Gainesville, Anthony Lyons, the city manager, said, we have plenty of food trucks. Why don't we create permit trucks? So that the permitting office goes to where the project is, not making the project developer go all the way downtown to where the city is. Goes back to the first question, what's the point of the exercise? And the point of the exercise is to make the city a place where people can live productive lives, do things that work for them, and we all end up having a better community in which to live. Those are two process examples that change the dynamic of the conversation and get us out of the box we're in, where, as you so accurately said, the only answer for the most part that a neighborhood is positioned to give is no.
Thank you, Alan. One of the things that I'm curious about is the extent to which, and especially for a city like Santa Fe that has such an important sense of place, such a unique city, how do you work preservation of the sense of place and of our neighborhoods into the idea that we do need more housing? I mean, it's just, the city will stagnate if we don't have housing for people to live here. All of our children will move away and all of that. Is there a mechanism for that, Alex?
I know.
Thank goodness, because we don't know anything over here.
Bueller?
I think that's an excellent question, and I want to see, if I had my Christmas wish list come true, Santa would bring me a centers and corridors map and get rid of the future land use map for the city government. And one of the things I like so much about the centers and corridors idea is that it focuses development on infill, on already developed corridors that have infrastructure, don't have a huge neighborhood impact, and resources can really be leveraged in those areas that are on transit lines, close to employment, near amenities. And what it does is you can block out the precious places, and those places don't change. But you can also look at the transitional places. If a certain area is zoned for a certain density, but we have way less development there, and we're able to reach the desired zoning density, you know, why wouldn't we? But so that's one thing. And then I think the city's inclusionary zoning, you know, it has its flaws, but I do think it is getting at the idea that we can create affordable housing everywhere. It's just we don't have development happening everywhere. So that's the limitation.
So adding to that, I think of a couple things. I think about making decisions around values and around principles that are generally agreed upon. So as an example, by show of hands, who here knows that the city council passed quality of life ambitions earlier this year? Okay, so our city has passed quality of life ambitions, a set of 7 different ambitions that describe, right, guiding principles for the type of city we are and want to continue to be and to evolve and grow into. So without all of you knowing it, we don't yet share it. So I think we need to do the second level of work is to ensure that we are doing the best we can to make sure that everyone knows this, so that we now have common principles that are trying to guide the choices that we're making. I think the second thing inside of those principles is that we are constantly evolving. And I think that we need to celebrate that we're evolving and celebrate our history at the same time. That we should look back and look around us at what is best about our heritage, what's best about our culture, what's best about us, and build off of that into a brighter future, as opposed to try to seal it up today as though you could preserve it in time, in a time capsule, and that it will be somehow perfect, right? It wasn't perfect 50 years ago. It wasn't perfect 100 years ago. 100 years from now, when people look back, it won't have been perfect today, right? But I think really honoring that and becoming very realistic and dealing with that, that is our life. That is how we are. We could, I think, have much more like compatible, much more collaborative, much more engaging and ultimately constructive choices and decisions that build off of our past into, I think, just a brighter, better, more amazing Santa Fe.
Can I take a shot?
Yeah, have at it.
Let me have a quick bite at that apple. First of all, I think it's entirely appropriate that a lawyer, our lawyer at the table here, is posing these as either-or choices. That's very appropriate, and thank you for that. Whereas those of us who don't live in the legal framework think about it as both-and choices or more of a narrative than even a either-or choice. And what Matt was just doing was telling a story. It's a story about how we put the pieces together so we have the best of the things we love, and we also migrate toward a future that actually keeps our young people here, creates jobs, maintains a highest quality environment of any city in the country, and produces a future we all like. I don't know how many of you saw the recent film Painting Santa Fe. If you did, if you haven't, you should. It's a phenomenal story about how Santa Fe got to be Santa Fe. And it got to be Santa Fe because we were in extremely bad condition. We didn't have an economy. We didn't get the railroad. And the city and the people who lived here were really worried about the future of this community. And out of that sense of danger came a willingness to take some risks, to try some new things, to invite artists and bohemians and experimenters and entrepreneurs into town, and created the Santa Fe that we now don't want to lose. We got it because we were about to go out of business. We have something now that if we only try to preserve it, we will go out of business. So let's do what my two colleagues have suggested, which is evaluate the things we love that we absolutely can't change, won't change, don't want to change, whether they are physical design specs or they are spiritual and emotional qualities that we cherish. And then let's look at places where we can build on those values. There's a movie, famous Western. It's kind of like The Magnificent Seven, but a little twist to it. There's a town that's under attack by the bad guys, and they send out for somebody to come help them. And the stranger comes into town, and he does a reconnaissance, and he comes back to the city elders and says, well, I've checked out the situation, and if you want everything to stay the same, some things are going to have to change. And that's the film we're in. If we want everything that we love to stay the same, some things are going to have to change. We know where we want housing to be built already. We've got the corridors identified. We've got targets of opportunity. We haven't implemented it, and so everybody's living in fear of what it might look like if it were implemented, rather than demonstrating that done right, it actually helps the city keep the things we love while actually then migrating toward the future where young people, workers, teachers, and people under financial stress can have rental housing they can afford.
May I add one more to you?
Yes, please. Build on me.
Yeah. Keep the people we love, right? If we don't have the housing, right, how does your kid, right, 18, 19, 20, stay, right? So it's that story. I'm sure everyone has heard that story, right? I am that story. I lived here in the early 90s, and I left because I didn't think I could have a career here, right? And I've heard that story hundreds and hundreds of times, right? So if we want our kids, the people we love, to stay, we also have to evolve.
Okay, why don't we open it up for dialogue with the audience for a while?
Okay, I've got one in front. We'll just start with the one in front.
Well, you knew I was going to talk. All of you have focused on how, in making decisions for the city, whether they're land use or something else, collaboration is more important. The Neighborhood Law Center, the Neighborhood Network, even, God forbid, the City Council have all supported for years ideas about doing land use decisions differently. I mean, there's a resolution. There's several resolutions on the book that explain how to do this. We've never done it. And the question is, it's fine to say that this is the system, and I would agree, but why hasn't it been put into place? I would say to Matt that if the city has quality of life principles, but nobody knows them, maybe those aren't the quality of life principles that people agree on. Maybe nobody paid attention to them and nobody came to the meeting. I don't know. There are cases of good developers and at least one developer of affordable housing that, in fact, do the right thing, that don't try to shove things down people's throats, that try to get them involved early on, that try to get their input. A lot of the input that's no is not so much the housing per se as the perceived effects of the housing. So I can think of a couple of workforce housing developments that have been approved. Haven't been built yet, I'm not sure why, but have been approved. And the complaints from the neighbors were about infrastructure, traffic. Is this going to clog up my sewer? And that suggests a lack of coordination at City Hall between the different departments. In answer to a question about traffic, the head traffic engineer for one project, the city head traffic engineer said about one project, well, the roads are what they are. We can't do anything about it. You know, people tend to get kind of freaked out when they hear things like that. So I don't think the question is, you know, what can be done. There's clearly a lot of models to get public input. Why hasn't it been done?
Alan, you had commented in when we were talking beforehand about a way of sort of negotiating with neighborhoods for development that I thought was pretty interesting. Could you share that?
Yeah, I think that, you know, you, as usual, you put your finger on a big problem for the city in general. And unbeknownst to most of you, I'm running for mayor. So I actually have opinions on these things. If you read the recently released audit of city government, you will discover that your question is amplified many times over. Why haven't we implemented the things we say we want? And I'm at least a part of it is, I think, the structure of city government has mitigated against it. We haven't had a strong mayor, and so we haven't had authority, responsibility, and accountability co-located in the mayor's office. It's very difficult to have government by a large number of people. Many years ago, the Chicago Cubs, as a sporting franchise, tried to have a different manager every day of the week. And they had 7 managers trying to manage the ball club, and I think they finished with the worst record in the National League that year. We've got great ideas, we've got great plans, we've got great resolutions that have been passed. We have not had coordination, implementation, and leadership in the structure of city government. As far as change, that's point number one. I think that's a structural issue, it's a leadership issue. It's not easy to change, but I think it's something we begin to work on with the new structure of government under this election. Whether I'm elected or not, it's the job of the next mayor to work on that. You also raise a question that Frank was referring to, which is, I think of it as, and this is sort of an entrepreneurial exercise, whenever you're stuck, reframe the problem. The problem we have isn't housing per se. The problem is we're not growing livable, successful neighborhoods. And so housing is a part of a neighborhood, but it's not the whole of the neighborhood. And so when neighborhoods get together and say, you want to put in housing, but it will have an adverse impact on traffic, air quality, noise, lack of public services, no amenities, that's really framing it the right way. And so I think in order to get us off the status quo problem we have right now, I would frankly favor building affordable workforce housing in places we've already agreed to put it, so we're not constantly going through this Pyrrhic battle with the neighborhoods. If we want to get to the issue of where to put it in neighborhoods, then I think you reframe the conversation. So I would believe that a mayor could sit down after studying a map of the city and talking to Matt O'Reilly and other people who know where the opportunities are and where the assets are, and let's have a series of conversations not about housing but about healthy neighborhoods. If you want us to have more housing so your young children can stay here, let's talk about a negotiation. What would it take for your neighborhood to accept 60 units? Is it about parks? Is it about police protection? Is it about transit? Is it about noise and a noise ordinance that protects you? The city ought to be, and the mayor, the next mayor, ought to be in a position where the budget, which will be proposed by the mayor, ought to be in a position to use the budget as a vehicle to create positive bargains, if you will, positive negotiations, so that it's changing it from housing to healthy neighborhoods. And that reframes it, I think, in a much more productive direction. We haven't been able to do that up to now, structurally.
It's at the books, we've just never done it.
So I don't know why, because I've only been here for 6 months, but I have a couple of maybe newbie observations. One, is it since starting here, I would say half the people come up to me and go, yay, we're so excited, woohoo, like I want to help you succeed in economic development. And then the other half of the people say, yeah, good luck, right? Nothing ever changes here. And in fact, if I did a Venn diagram, a lot of those are actually the same person. They just come to me twice and say two different things. And I think that we, all of us, see each other in the roles they are rather than the person that they are. So when you come and look at me as a city employee, do you think that I'm empathetic, that I'm smart and capable, that I'm really energetic and working my hardest on behalf of you? Right? Or might you think I'm kind of lazy and don't really care that much and just punching the clock? Like, what do you think about me just by knowing my title? Right? And I think it goes every which way. So I think that in order to evolve the way we want to, we all have to find our way to having greater empathy and seeing each other as people. And you can set the ground rules for doing that. Like when you engage in these different processes, there's ways of setting that up. Right? There's tools, there's techniques for building empathy so we can see each other as people. So I believe one of the reasons why we haven't done this is because we're not really oriented yet around real empathy and seeing each other as in this together. So that's what I have to contribute to that. I think the other thing is that I suspect that many things have been tried. I suspect that things are tried, they fail, but they try. Right? We've seen actually many different housing efforts to be tried and they failed. A question I have is, what are we learning about those failures? Because it seems a lot like we're doing that, like the definition of insanity is doing the same thing again and expecting a different result. Right? It does feel a little like we get into that, whether it's in land use and other places. So I think we on the city government side, on neighborhoods, us together, I think we need to do more diagnosis of what worked and didn't work for continual process improvement, so we get better and better and better over time, as opposed to more frustrated over time. So that's my other observation about what I see going on here.
Yeah, I just wanted to add that I like both what Alan and Matt had to say about that, but I also want to say there's a lot of really, really good stuff happening within the city government. There are a lot of really smart, capable, talented, committed people working really, really hard. We don't do good PR on that. You know, Matt mentioned the quality of life that nobody knows about. Well, there are lots and lots of things that are going on, you know, behind those city doors that's great. And we don't do a good job of talking about it. We don't do a good job of involving the community in it. And then the one, here's my little pet peeve, is when the New Mexican loves to grab a story about some sort of crazy incompetence of city government. And it's, to me, take notes here, Alan, in case you end up in that position. You know, it's a bummer, to use a really trite word, when the elected officials will take that story on as if that's the truth. And so they, you know, well, we're advocating up here for the public because of all this incompetence. And, you know, you're standing there looking at them like, wait a minute, you didn't ask me for my side of the story. So I think, you know, these structural challenges are big and they're real, and there's lots of work for everyone to do.
I think I have another pet peeve, and I'll use I'll use the Rolling Stones. You can't always get what you want. Okay, so what I also see here is it really feels like often that we individuals feel like they should get everything that they want, right? But really, I think we all deserve and have a right, Alan said earlier, to be heard, to be respected, to be treated with dignity. But you actually don't have the right to get everything that you want. And in fact, I think it's to turn it the other way around. What can I share? What can I give? So that you can have something and I can have something, so that we can have a better place. But that philosophy, just that orientation, can we come together going like, I expect not to get everything I want. I expect to compromise from the beginning. Right? That would be beautiful.
So you all are talking about processes, procedures for making decisions, and potential chips that the government can play with neighborhoods to try to get buy-in by the neighborhoods. But what about the private sector? And what is it you think needs to be done to ensure that, let's assume that this paradigm shift you guys are all talking about happens. That's nice, but how do we make sure the private sector then responds with the housing units and the economic opportunities that's part of what we want here? And I agree that making it easier for the private sector to deal with the city government, making it easier for the private sector to deal with neighborhoods, and a more rational, coherent, cooperative, collaborative process will go part of the way there. But ultimately, the private sector's in it for the buck. And what do we know about whether, if these changes happened, they would come?
Well, Charles Howdy. I'll go quickly because I think Alex would probably be much more intelligent than I. Yeah, well, she's always more intelligent than I, so I better say something quick. I think step one is we got to knock down the barriers, the kind of like the self-imposed pain that we put on not just the private industry but residents. Right? So that's level one. Level two is that I have seen, I see documents, I see organizations that are explicitly expressing their interest to invest in housing in this city. So I see it. It's not a theoretical thing. It's literally there. People are there and want to do it. But we are making it, the barriers currently are too high, and they're self-imposed, whether it's from the city government or the strategy that we're using that then sort of trains neighborhoods to say no right away to exert control. But people are there. Did I get it right?
Sounds good to me.
Okay, good. Not everything, but I see it.
Yeah. And I think that's one of the things about inclusionary zoning that I really, really appreciate and enjoy working with is that it requires a private developer to subsidize the sales price or the rent of a certain percentage of units. But then hand in hand with that is a nonprofit service provider is preparing that home buyer to buy that unit. And so my job is to kind of bring everyone together and provide the incentives I can provide, the fee waivers, the discounted building permit fees for those affordable units for the private developer, but also try to make the transaction as easy as possible.
Do you see more around? Yes. Can I borrow? Yeah. You go ahead. You're on. That's your bailiwick.
Someday. Yes, so we, in 2016, the mayor and I worked on amendments to the inclusionary zoning program to allow developers of multifamily housing to pay a fee in lieu of providing units on site as an incentive to try to remove a major barrier, because what works well on the homeownership side is much tougher on the rental side because it's an ongoing hit to an operating budget to have certain units that not only won't turn a profit at all, but they're costing the owner money to maintain. And so the idea was because we have such low vacancy rates right now that we need market rental as well as affordable rental. And if we can sort of let a little of the steam out of the pressure cooker, that frees up the market for everybody. And I base this on a lot of conversations with private developers who said, hey, Santa Fe's off the table for me. If I have to provide these deeply subsidized units in my property, I can't get financing. It's not that I don't want to do it. I cannot get financing because my bank is running out the door when I'm showing them how I'm actually losing money on 15% of my units. So we've amended the ordinance and we're allowing a fee in lieu. There is a sunset clause on it of 2020 to see, first of all, to see if it works and also to see if we can figure out a better way to also create the units hand in hand with the market rate units.
Can I just say one quick thing?
Sure.
One quick thing. I promise it'll be short. This is where Frank's earlier question about housing and jobs being two sides of the same coin. We know that and this is to your earlier point about not telling our story very well, there's an enormous amount of economic activity going on in Santa Fe right now, both visible but also below, under the radar screen. I sat down with a couple of folks yesterday who were describing a Santa Fe software company that recently purchased a German software company. I mean, we have a business here that bought a company in Germany instead of the other way around. Things are happening. The gating influence on this pent-up economic energy that is really going on in our community is housing. And the ability of young, usually young and people getting started in their work lives to find that affordable rental units. And it is, it really is true. They're already here. We don't have to build it so they'll come. We have to build it so they'll stay. And so the companies that are here that are growing will really be able to have the workforce they need. So I think the private sector is going to be fine. I do think the mayor has the ability to convene and bring people together and actually articulate a strategy that people don't see right now. That also changes the narrative and the dynamic in the private sector, thinking we now have a partner we can work with to do public-private investments. So I'm very optimistic about that. I do think we got to get over this hurdle, what Matt described as the pain points. Sorry, your turn.
Thank you all for the conversation, and I want to thank Alex for years of working on this stuff in City Hall.
Yay!
In fact, when I first moved to town, which is 1995, we were in the middle of a pretty deep and wide process, which was the rail yard community planning process. Huge commitment from the city, from a number of nonprofits, from many, many, many community members. It took actually a number of years and some money. In fact, I've been back here thinking, when is the last time we really did a very, very inclusive community planning process? I'm not sure I remember. I know there have been bits and pieces over time. I worked with the Land Use Resource Center for a million years, and so we worked with the city a lot. Alex and I worked on the inclusionary zoning ordinances at both the city and the county. But I think a while back, because of probably resources, among other things, I think we sort of gave up having these very inclusive processes about, well, what do we want the city to actually look like? We've done some very good sector planning, I think, haven't we, over time? But I would like to say I really agree with you guys that one way or another, we have to be able to engage the community, all the community at a deeper level, and pardon me, not only retired people who can go and live at City Hall and go to meetings all the time, because that's a big challenge. There are many, many people in many parts of this community who work very, very hard at a number of jobs to be able to raise their kids, feed their families. I'm not sure we've quite figured out how to be really inclusive in terms of finding out what people need and want. And I would like to say that I think the emphasis on workforce housing is really important, really, really important. But we have had the challenge, and we've had it for a long time, that where we have individual pieces of property in or adjacent to neighborhoods, we seem not very good at maybe working with the neighborhoods in coming up with some way to develop those things effectively into workforce housing. And there are times, and there were a couple right at the beginning of Mayor Gonzalez's administration, a couple of big projects, one by the river down near our neighborhood, and the one up in the second district that weren't actually really very good projects that were proposed. They were oversized, overscaled, and so I think also there needs to be some nuance when you're talking about affordable housing or workforce housing or whatever kind of development. Because sometimes people aren't totally opposed to something, but they can see when something isn't the right thing. And so there needs to be real input. Just one final comment. When I moved to town, we were working on the early neighborhood notification ordinance. I'm not sure how that works now. But a lot of people worked hard to get that into place in this town. Maybe that needs to be tooled. I'm not sure what needs to happen with that. But as Karen pointed out, we also have supposedly have neighborhood planners. You know, we have a lot of tools. So the question is, are we using those tools? Do we need to relook at those tools? Do we need to reinvent those tools for 2017 and 2018? How do we work together to make this stuff be so in a way that is inclusive for all the community? So thank you for all your efforts. Maybe that wasn't a question. That was sort of a diatribe. But feel free, please, to respond, because I'm curious as to what you guys have to say.
I was going to ask the panel a really hard question, but I see we only have 1 minute left, so I'm thinking better of it. Peter, do you have anyone else?
Well, we did have, Kim wanted to ask something quickly, so we'll try and squeeze it in here.
Well, I'm going to ask it to Frank, actually. Frank, there's two pieces of apple pie in front of us. Both of them are very tasty. Our moms would love them both. One says that we recognize that affordable workforce housing is necessary and higher density is the way to do that. I think everybody agrees on that. The other is that we need to preserve our neighborhoods. Zoning enshrines discrimination across our city. As a former city attorney and a member of this neighborhood law center, is it time for us to actually rethink about the future land use map enshrined in the 1999 general plan and recognize that zoning is the problem?
Yes.
Your succinctness is much appreciated.
The question that I had is, I've heard the complaint that it's just unfair to try and stuff all of this new housing, rental housing, workforce housing, whatever you call it, in the south side of town. And my question is, to what extent should every neighborhood be required to work through where they wish to put additional housing, more dense housing within their neighborhood? That's certainly, to me, then I think you get into the kind of process of, okay, they say we who live I live on Upper Canyon Road, we have to figure out a place in our neighborhood that this will work. And I think maybe that's a way of bringing a greater degree of equity to the city and realizing that, oh, we really have to have this housing. Let's think of where in my backyard rather than not in my backyard.
Thank you. And step back to the panelists. We are at the 3:30 break, and please do, if you're taking the trust accounting credit, you need to sign outside. It's administered by the New Mexico Bar Association. They are out there with a sign-up sheet. So if you're looking for that one credit, and it is an important credit for a number of our attendees, please do go outside and sign up.
Listening to us? They get credits for listening to us? Yeah. Crazy. Frank, that's a scam.
It is.
I think it's going to work.
All right.
No, I think it's going to work.
There's a downside and an upside.
Thank you, Alex.
Oh, so you fixed it for the...
I think we fixed it for the other presentation, and I think, yeah, if you want to test it now, it's fine. Just give it 15 minutes.
Is this a reunion?
Yeah.
Yeah. Why can't we do these things, Karen? Why do we say we want them and then we don't do them? I'm not talking about development. Why the city says we want this and then it doesn't do it? Why not? City council passes resolution saying we want this, that, and the other thing, and then they don't do it. Why not?
I will send you a specific instance I have been working on, much more limited than what we're talking about, and you will find it.
All right, good. Case study.
For now, I'm going to need it.
Yes, actually. We bought a house in 2003, moved here. Took us about a year to disentangle ourselves from where we were in Boston, so 13, 14 years.
3 miles down.
That's my
So
back.
if you go down, you know Jonesboro Road. Right, so if you go past the Wood Ranch, keep going, you hit an arroyo, and you can drive across the river to the other side. But instead of going across, you just go up on the other side of the arroyo, and you go to the end of that road.
Well, I think it's two sides of the same coin. We got to have them working together. No, certainly.
Really, she's now
I agree. We gotta grow the economy.
architects and a general contractor.
Or for this government.
Yeah, sorry, commercial.
We actually have to build the
She
economy.
might come out here maybe.
And there are some signs of life. We just need to grow them. Yeah, there are some really good green shoots coming up, but it's up to the city to try to grow it. You got to tell the story. Yeah, make them feel welcome. Support them. Yeah. Oh yeah. This game. Yes. The game is afoot.
That's okay. I take no offense.
He went to a third psychiatrist, told him the story, and said, well, you could waste your money on me and it won't help. We know that institutionalizing won't help either. Like on his third option, move to Santa Fe where it won't be noticed.
Yeah, I knew that was a setup.
And then, 1970.
Right, that was being said. City
Some people come here.
Yeah, that's me.
We're not really super good at technology. People know. So as long as it's working.
And here's the other thing I'll tell you. I've learned enough from doing these in the webpage of
Well, when you had a
No, I was way off.
Computer legal research, but the Michigan get yeah, see, you got everything.
If this goes down on me, I can do it. Here's the other thing. I can do this from memory of my sleep.
I don't know if you already built into your presentation. We're still on average, routinely are 70 years of scale in the average. You know, when you want to just do a procedural part of the team, okay, this is working on this is what I think, and this is what I think we all need. We do a full 12 credit hours, 3 to 5,000, 18 to 22-year-olds, many of them are around there every year. We do that. Like, we need the college town part of San Jose, which was a college part, and then we have this cool, like, interesting urban part where it stays up at night. We need a place that stays up till 2 o'clock every single night, and it's full of young people and young families.
Well, we do know that before we became a state,
The answer is no.
I know, that's why
we
I'm
chose
saying.
the prison over the
Yeah, fair
university.
warning, right, yeah, 30 years ago.
And we also,
We don't have, we
the
don't
rich
have.
people bought a track, I mean, the right of ways for the Santa Fe Railroad. That's why Lady is where we go to get on the train, because it's really, we've been really for a long time.
Nice to connect.
Yeah, the incoming president for the road crew, I've been working with Alex.
With the who? Oh, there's a pickle.
I've been working with Alex. Really gonna make a huge change. Super involved. It's great. I've been on a bunch of these committees trying to start something. Not there in the past.
I think my contribution to this is like there's many ways to try to solve this problem.
I think they're all handheld up. Yeah, they are computers.
Yeah.
We're deciding, and now you guys figure out, you got a year and a half to figure out where you want to put your 1,000 units. There's developers, a bunch of people will help you do that. If you don't do it, then we'll do it, then we'll do it, we'll impose it.
It's 3:42 now. We still have 3 more minutes, so feel free to take them. But I'd like this next panel to start right at 3:45, so everybody can get out right at 4:45. The city does have, they do need to clean up the building after we leave, and so leaving them that 15 minutes is a good thing for them. So 3 more minutes. Yes, if everybody can sit down now, it is time to start our final panel for the day. I'll allow Bill to introduce himself. I think he spoke with us last year, and so I think most of you are familiar with him anyway. But he'll do his own introduction, and he's going to present you the 1 hour of credits that's required for the new trust accounting requirement, and he'll explain all that to you. Thanks.
Hello. Really? That's it? One guy in front? All right. So we're going to spend an hour talking about trust accounting. Isn't that exciting on a Thursday afternoon? Yay. It's going to be more exciting than you think. So it really will. So there's a couple things that I want to start with, which is I'm not much for saving questions to the end. So if you have questions as we go, you should just raise your hand and ask them. And I understand you'll take the microphone to them. And it doesn't have to be about trust accounting. It can be. But if you want to ask me anything about the discipline system, that's fine. If you want to ask me something about a problem your friend is having, that's fine. I'll try to give you some general advice and guidance. Nothing that's going to be binding in terms of if you actually have a complaint against you, we're going to go through the normal course of business. But if we can talk about an issue that you're having now, that's fine. And if you don't feel comfortable doing it in front of everybody, fine. Come and grab me before I leave. Send me an email. Call me. We really are trying to work on higher visibility through the Office of Disciplinary Counsel and serve more as a resource so that people can reach out to us and get help before they get themselves into a fix. All right? So that's the first thing. Second thing is that I'm hoping you all, or at least enough of you, brought smartphones, because this is actually an interactive presentation so that you're going to be participating, and it goes a lot better if you actually participate than if I just stand here and talk. So we're going to talk about the rules of trust accounting and how you comply. And 17204 is the rule. At some point between now and the end of the year, you should go read 17204 if you haven't, and the new version, not the old version. It's got a lot of good information and will help you stay in compliance with the rule. All right, and we're going to start with some basics. 17204 is the rule that talks all about how trust accounting is done, but 16115 is really the rule that engenders 17204. Anybody remember what 16115 talks about? It's on the screen, so it should be easy. Yes?
Unearned fees go into an IOLTA.
Right, unearned fees go into an interest on lawyer trust account, right? So it's IOLTA. And basically what 16115, it's the safekeeping rule, and what it means is client money goes in an IOLTA, third-party money goes in an IOLTA. Any money you're holding for anybody who's not your money goes in an IOLTA. And then your money goes in your operating account, and never the twain shall meet, mostly, right? And if the two do meet, that's called commingling, and that can be an issue that we'll talk about in a few minutes as to why that potentially is a problem. But 16115, that's basically it, right? And I think almost every law student that you talk to that comes out of law school, the first thing they will tell you if you ask them what's the deal with trust accounts, well, that's where the client money goes, and that's about what they know. Right, so part of the idea behind this course is to make sure you know more than that. I will tell you that I'm lucky to teach at UNM at the School of Law. I teach the ethics course once every year, so in the spring semester. And one of the things I've started making the students do is actually run a mock trust account through the course of the semester so that when they get out of law school, they have some idea of how a trust account actually should work. All of the things they need, what goes into them, how stuff comes out of them, that kind of stuff. All right? So you're going to get the mini version today, I think. All right, and the first thing we're going to talk about is unearned fees and non-refundable fees. And for that, this is where I need your smartphones, if you have them, or even if they're not so smart, just any phone that can text. And then you go to your message screen. You guys know how to do text messages, right? Some of you? So if you go to your text message screen, and in the to, so you're going to be sending a text message to, the recipient is 22333, 22333. And then in the content field, so what the message is UPL2. You can do uppercase, lowercase, doesn't matter, just so you get UPL2 in there, and then press send. And when you press send, what you should get back is this message. You've joined William Sleese's session UPL2. When you're done, reply leave. I'll try to remind you to reply leave. That way, you know, my phone's not ringing at night giving me updates on what you think about trust accounting, right? The other thing I tell people is this is anonymous polling. I have no idea how many of you are participating. I have no idea who's participating. I have no idea if you have the wrong answer. And frankly, I hope some of you get the wrong answer, even if you do it intentionally, so that we have a talking point. That's fine with me. All right? Some of you have that? Some of you have you have joined? Yes. Good, okay. So you're going to stay with that for the rest of the questions that I ask you. And then it's just like texting, except you're texting one way, and then the texting back is going to be up on the screen. All right, so here's the first question. Having to do this is A, delightful, B, necessary for credit, C, annoying, D, who said anything about mildly annoying? Right, so A, B, C, or D, enter that in the content field and press send, and we'll see what you guys think. And hopefully the connection in the room is good enough. Yeah, see, it is. So some of you are honest and said, who said anything about mildly? Some of you said delightful. I would remind those people you should be honest with disciplinary counsel, right? And most of you said exactly what I expect you to say, which is B, once every 3 years you have to take this class, or in 3 years it'll be a little different, but you've got to take this class for compliance purposes if you're not otherwise exempt from the trust accounting requirements under 17204. People who are exempt are primarily public employees who don't hold client money, right? Everybody else pretty much is going to have to take the class. And I'll tell you, part of the motivation behind the class is what we see from the disciplinary board standpoint as to violations of the rules of professional conduct. We see all kinds of violations, but including trust accounting. How many of you think the trust accounting violations we see are primarily people stealing client money? Yeah, you think that? There are some of those, right? And if you're really itching to stop the practice of law, one good way to do that is stop is to steal client money, and then we will ask the Supreme Court to have you stop practicing law, right? And conversion of client funds is really one of the quickest ways for the court to get interested in either long-term suspension. Really the presumption starting with conversion is disbarment, and of course disbarment in New Mexico now is permanent, so once you're out, right? There are some theft cases for sure. Most of the trust accounting problems we see are not theft cases. They're not conversion or even commingling cases. They tend to be more poor record keeping and people who just don't know how to operate or maintain or record keep for a trust account. And the problem associated with that is then you can start getting into trouble because you lose track of client money and your money, and that then can lead you to some more serious problems. So part of the idea behind the course is to educate to compliance, and really that's a thing that we talk about a lot now in my office. The idea of proactively regulating, in other words, trying to find ways to intervene and educate early so lawyers don't get in trouble, rather than wait until you do get in trouble and then have to go through the discipline side. All right, so necessary for CLE credit, you're absolutely 79%. So let's go back to non-refundables. The idea that a client gives you money that you have not yet earned and that you're saying, I don't have to pay back. So can an attorney designate a retainer fee as non-refundable or earn when paid? If you think they can, you should say A, true, and if you think they cannot, you should say B, false. And by the way, I'm happy if you don't have a phone and you want to just shout out the answers. Fabulous. So going back to about 2000, there's a case called In re Dawson. There's a companion case called In re Yalcutt. And then last year there was a case called In re Montclair. All three of those cases stand for the same proposition, which is that lawyers cannot charge non-refundable fees in New Mexico. If you have or what's also termed earned when paid fees. And what I will say to you is that we often, at least once a month maybe, it's starting to slow down now because the word is getting out. But at least since I've started in the office, which is 7 years ago, it's not uncommon for us to get a retainer agreement between lawyer and client which uses either the language, this fee is non-refundable, or this fee is earned when paid, which is the same concept, right? And when the lawyer does that, where do you think that money goes? Where should it go and where does it go? If somebody's saying it's non-refundable, it's earned when paid, where do you think they put it? Right in the lawyer's operating account, right? Which is improper because you can't charge a non-refundable earned when paid fee. So it should go into the trust account, right? Look at any one of those cases, they will tell you that. Now, I think where some of the confusion about non-refundables and whether or not I can have an earned when paid fee comes from the phrase flat fee. So let me ask some of you, any of you do any flat fee work? Criminal defense work, yeah? You do some flat fee work? What kind of work do you do, sir? Some incorporation, so you'll maybe charge a flat fee for that. You're going to draft some documents. You're going to file with the Secretary of State or the PRC or whoever you file with now. Secretary of State, right? Oh, nonprofits, okay. So IRS forms is what you're doing, right? And anybody do criminal defense work in the group? That's often a common area where sometimes people will charge flat fees, especially for some of the magistrate court misdemeanor stuff. DUIs and that kind of stuff is not uncommon to see flat fee. You may have a better feel than I do. $4,000 to do a DUI? Ah, okay. So you're doing pro bono work. All right. Well, let's say $4,000 to do a first-time DUI, right? Misdemeanor level stuff. Can you charge a flat fee like that? And really the question is it unethical to charge a flat fee? If you think it is, you should say A, true. If you think not, you can say B, false. And what I'll tell you is, while you're doing this, Flat fees are not uncommon in the criminal defense area, sometimes in the family law area, and a couple others, estate planning, sometimes in corporation work. Flat fees are not per se unethical. You can charge a client a flat fee. Now, for the client, what that means, why would a client want you to charge a flat fee? What's the benefit to the client? They can budget, and there's certainty, right? They know how much their representation is going to cost them. What if you're just really bad at judging what the case is going to cost time-wise for you? And so now the $4,000 case turns out to be a $10,000 case. Who's going to eat that, so to speak? The lawyer, right? If you tell the client, here's what I'm going to cap your fee at, then that's on you, right? The flip side of it, and this is where the non-refundable comes in, is what happens if, so we take a DUI, I'm going to charge you $4,000. A week later, you get a letter from the DA who is so impressed with your legal prowess that they say, hey, I'm noli prosing this case. I do not want to have anything to do with you, right? That happens to all of you, doesn't it? You guys are like tired on Thursday afternoon, right? So what happens when it interrupts? Now, at that point, all you've done is maybe an initial consultation with the client, and maybe you gathered some documents. First off, where should the $4,000 be? In the trust account, right? Because you haven't earned it yet, except maybe a little bit of it. And now what happens when the client comes in and says, hey, representation's over? You get to keep all $4,000? You charge them a flat fee? No, right? Because if you kept all $4,000, that would be in violation of what we just said, right? Dawson, Yalcott, Montclair, which specifically say non-refundable fees are per se unreasonable under 16105. So you can't do that. So you're going to have to give the client some money back. How are you going to do that? You're going to give them all $4,000 back? You did put some time and effort into it, right? You gathered some documents. There was probably some hard costs there. Maybe you spent a couple hours meeting with them. Maybe you spent another hour gathering the documents. Maybe an hour convincing the DA how awesome you are, right? So now you've got 4 hours into it. You've got $125 in hard costs for the police report and the breath analyze and all of that. What are you going to do? You're going to give them all $4,000 back? Yes, sir.
So I think you should have in your fee agreement to begin with the fact that if the process is terminated before you complete the work, that you're going to get billed an hourly rate of $400 an hour, and that takes care of it.
All right, so what he's suggesting is in your fee agreement, you should have something that says, if this terminates early, you're going to get billed at $400 per an hour. Anybody object to that? First off, damn, $400 an hour, that's pretty good. It's been a while since I've been in private practice, so that's good. Congratulations, right? Whatever your hourly rate is. And really what he's touching on is the concept that you hear in the cases that talk about flat fees and non-refundable fees, which is you have to earn a flat fee in increments, right? So when the client gives you that money at the beginning, none of it's earned, it goes in trust, and then you earn it incrementally. It can be, the most common way is exactly what you said, hourly, right? You can calculate the number of hours times the hourly rate. That's in your fee agreement, and the client is able to calculate with you. You can sit down, here's how much you're getting back. Here's how much I'm keeping. Another way, and it depends upon the nature of the practice, but another way you can do it, and they're called benchmarks, is by case events. So it can be, in a criminal matter, it can be there's a preliminary hearing, and then after the preliminary hearing, there's some discovery with the state, and maybe there's some pretrial interviews with the cops, and maybe after that you're going to go through some motion practice. Maybe if it's a more complicated DUI case, maybe there's some expert practice that you're going to have to do, right? Experts on both sides. And then you're going to have a pretrial, and then you're going to have a trial. Each of those are sort of natural breaking points in which you can estimate the general amount of time and effort you're going to have to put into it, and how much that breaking point, up to that point, what the client would have to pay to get there. And it just has to be reasonable, right? Which is a little bit of subjectivity, but reasonable in terms of the world. The idea being that you can't say, well, I'm going to take $4,000, $3,999 of it are going to be for the preliminary hearing and $1 for everything else, right? That's not a reasonable benchmark. It's got to be something that really approximates what you would have into the case when the representation terminates at any sort of midstream point. So you can charge flat fees, but they have to be refundable, and you have to have a method that you and the client agree on, excuse me, that you can calculate the refund, all right? Now, you still need a trust account because That's where the money has to go. How about an accounting? Do you still have to give them an accounting in a flat fee case? You told them I'm charging you $4,000. What's there to account for? The case is over. We went through trial. I got you an awesome result. You were acquitted. You have no right to know how I spent your money, client. Right? Does that give you a hint what I think the answer should be? Yeah, absolutely. You still have to provide an accounting in flat fee cases. Now, if you read 16.115, there's a specific requirement in there that says you must give a client an accounting in a reasonable time after the client requests it. So if a client writes you or calls you or emails you or texts you or whatever they do to contact you and say, let me have an idea of how you spent my money, give me an accounting, you've got to do that within a reasonable time. What do you think is reasonable? 3 months? 3 months reasonable? 3 months feels a little long to me. 1 day? If you do it in a day, fabulous, right? Something in the neighborhood of a week to 2 weeks, understanding that sometimes maybe you're right in the middle of a trial or something else where somebody gets back to the client and says, we're working on it, we're going to get it to you, here's why we can't get it to you in the next week. It's just something within a reasonable amount of time. Now, 16.115 doesn't specifically say that you have to give them routine accountings. I would tell you that I think you do anyway under your communication duties with a client. I think you need to be telling them how you're spending their money even when they don't ask. And there's another pragmatic reason for you to do that. What do you think that might be? Why would you want to tell your client how you're spending their money periodically, even if they haven't asked? Yes, sir. Because you want them to think you're an honest lawyer, and partly, you probably want them not to be anxious about you and at some point complaining to me because they're anxious about you, right? So we get about 650 to 700 complaints a year against actively licensed lawyers, of which we have about 7,200. And that's roughly 10%, and that's about an average nationally. Of those, 8 to 12%, sometimes 15% result in actual discipline. Well, that tells you that about 85 to 90% result in no discipline. And of those, a fair number are what I call customer service complaints, right? Complaints where the client is extremely anxious, mostly because they don't think their lawyer's moving fast enough, and they also are not communicating with their lawyer in the way the client thinks they should be. So the lawyer's not calling them back as quickly as they think, or responding to emails as quickly as they think, and it's not to suggest to you that you have to acquiesce to unreasonable demands of somebody asking for communication, but part of those communication breakdowns come because the client has no idea how litigation works, especially if it's a litigation practice, but even a transactional practice. How long things take, especially in litigation, how sometimes there's long periods where nothing's happening, right? So it's important when you have that first meeting with the client to set those expectations so the client understands how you're going to do the job, when you're going to communicate with them, how often they're going to hear from you. And one of the easiest ways to communicate with them is monthly. Send them an invoice and tell them, here's what's going on with your case, right? They can get a lot from that. And sometimes nothing's going on and you just tell them, I'm not billing you this month, but I just wanted to check in and let you know, still thinking about your case, right? So that takes some of that anxiety away. So yeah, I think you've got to give them an accounting when they ask. For sure you have to, and I think you should do it routinely, including in flat fee cases, right? Now, you have to keep meticulous records. If you go and read 17.204, it will list all of the records that you're expected to keep that constitute trust records. You'll notice one thing that's not on this list, but it's one of the things that is part of your trust records are your bank statements, right? And then there's other things like general ledgers. You guys know what a general ledger is? I will not call anyone out or take your name down if you tell me you don't. But what's a general ledger? Who can tell me? What's another way to think about general ledgers? Right, a check register. Yeah, absolutely. And so if you talk to lawyers who are starting to practice within the last 4 to 5 years, unless it's a second career or they've come to the law later, if they're of an age group that's more in the 25 to 30 range, they've never seen a check register, a lot of those folks, right? Because that's not how they do business. They do all of their banking through the technology, primarily their smartphone. In fact, when I ask the ethics students every year what a general ledger is, most of them don't know. And when I say, well, how many of you have ever balanced your checkbook? They ask me what the hell that means, right? Because that's not something they do. They primarily deal with their checks. They don't deal with checks. They deal with their checking account electronically It's primarily ACH transfers, and then they can look at their phone and they know what their balance is, and I'm talking their personal account now. That doesn't work for trust accounting, right? For trust accounting, you're going to have to keep hard records of things like a check register, which is actually a general ledger. So a general ledger is nothing more than a running list of everything that goes into the trust account and everything that comes out of the trust account, right? And contemporaneously, right? So for whoever the client is, for whatever the purpose is, if it's going in the trust account, it gets recorded. If it's coming out, it gets recorded. Date, description, client identification, amount, and then you keep a running balance, right? So at the end of the month or whenever you do your reconciliation, you can stop and see what you think should be in your trust account, right? And then you're going to keep client ledgers, which are really nothing more than a general ledger for each individual client. So for each client, you're keeping trust money, everything that goes in and out on behalf of that client. So already that tells you that one transaction means you have at least 2 entries to go make, one in your general ledger, one in the client ledger. And in the client ledgers, you keep that same running balance so you know not only how much money is in your trust account from your general ledger, how much of that belongs to Jane Doe, right? Reconciliations, we'll talk about what that means in a minute, but it's basically balancing your trust account so you know for a fact what's in there. Deposits, checks, withdrawals, bank statements, and there's other stuff. Occasionally, complaints lead to our office asking a lawyer to see their trust account records. What do you think they send us when I ask to see their trust account records? Bank statements. What else? You guys are quiet. Is that because you don't think we get anything else? That would be the right reason for being quiet. Because that's about all we get back in the typical, not typical, often. That's what we get back when we ask a lawyer to see trust accounts. They send me their bank statements. That's not your trust account records. It's part of them, right? Partly we can get those anyway because we could issue a subpoena to your bank and get those. That's not going to tell us the kind of things we need to know to determine whether you are adequately complying with the rules for trust accounting. And I'm talking more than just are you crossing the T's, dotting the I's. Are you actually managing the trust, the client money, in an appropriate manner? You're not commingling your own money in there and you're not taking your client's money before you've earned it, right? So I need to see more than just your bank account. How long do you have to keep the trust records? So make sure, by the way, if you haven't, go back and look at 17204. Don't panic if you haven't been keeping all those records. Start keeping them now, right? But how long do you have to keep the trust records? And if you don't want to put it on the screen, you can shout it out. How many? 5 years, this gentleman says?
Statute of limitations on malpractice.
Statute of limitations on malpractice is how long? 3 or 4?
I haven't had to find out.
Thank you for sharing.
Forever, so it doesn't matter to me.
You keep yours forever, so you would have said D.
No, I wouldn't. I don't have to, but I do. So
Ah. Now see, that's very good. Now how do you keep them forever? You have like a couple of tough sheds at the back of your office in which you've got just, yeah? That's good, I suppose. What happens if the tough shed burns down? Let me suggest to you, you can definitely keep them forever. One way to think about keeping them forever would be to have them digitally saved, right? Scan them and save them. And by the way, if you're digitally saving things, make sure you've got a backup somewhere that's off-site so that if the place burns down, you don't lose everything. And by off-site, I don't mean you have to store in the cloud.
I have a question about that. Is it ethically okay to store in the cloud?
And I'll answer that question. Some people will do it internally, right? And if you do it internally, that means you've got another server that you're backing up to. All I'm suggesting is you take that backup data off and lock it up somewhere so it's secure and safe. Is it ethically okay to store in the cloud? The short answer is yes. There's a few things that you have to do. One of the things, so that you know ethically, to store in the cloud, first off, to store in the cloud means that you're sending data, your stuff, probably your client's confidences, over the internet somewhere else, right? And then they're showing up on a server in a storage farm, and they're keeping that stuff, right? And I'm not endorsing any in particular, but there's plenty. There's Just Cloud, there's Carbonite, there's some Google products, there's a bunch of them that'll store data for you at a cost. You can do that. You have to make sure that when you send the data out off of your computer, that it's encrypted. And then it should be on an encrypted line, and then when it gets to the cloud farm, it should be re-encrypted again. And only one person should have, or one organization should have access to that, meaning only one of you should have the decryption key. That's you, right? It's your data, your client's data. You don't want the cloud farm folks to be able to look at all of your stuff, right? And then you want to know if they get subpoenaed, will they let you know so that you can fight the subpoena, and will they resist it? Which means that you're safest at using a US, doesn't have to be a US-based company, but US-based storage facilities. And then you want to make sure that there's redundant backups going on. Because think about this, if you send all of your data to one place and it burns down, now you have no backup. So what you're going to want to see in your terms of service contract is that they use multiple server locations. So maybe there's one in Iowa, and maybe there's one in New York, and whatever, right? But that's maybe a little longer answer than you were hoping. The short answer is, yeah, you can store in the cloud. You just have to take reasonable steps to protect it, because otherwise you're sending confidences out. I'll tell you what makes me more nervous than the cloud are your smartphones and your computers, because if you're not password protecting these with pretty robust passwords, people have all kinds of access to all kinds of confidential information about you and your clients.
And this is probably a pretty good time for me to mention that the internet access that you're using on your phone right now is on an open source that's not password protected, because that's what the CVB uses.
Right.
So that would be a good example of where you're sort of at risk. You wouldn't want to be sharing your client information right now.
Exactly, because anybody who can tap into the signal would be able to see what you're doing, right? I will tell you, for example, on this computer, there is this, and if somebody wants to tap in and see this, knock themselves out. Hopefully they'll learn something from it, right? So I'm careful about not keeping confidential stuff, and if this was the computer that sits at my desk, I would not be tapping into this network because it's open source, right? All right. For those of you who said 7 years, why'd you say 7 years? It's not wrong necessarily. It's actually good practice. 7-year itch for the IRS at least, right?
I think my malpractice companies has advised that I should keep it for
7 years. And they're probably also tying it to IRS, right? IRS look back is 7 years. So forever 7 years, nothing wrong with that. The rule actually only requires 5 years. I'm glad to see nobody said 1 year. So if you're doing it 5 years, you're in compliance with the rule. 7 years better, forever best. So nice job. Yeah. All right. Overdrafts and cushions, they're not sunshine and rainbows, that's true. So you all know how IOLTA works generally? What happens is a bank or a credit union now says, I want to be able to offer to lawyers IOLTAs. And they now contract, it used to be the Center for Civic Values, now it's the State Bar of New Mexico. That's not us, that's the State Bar, right? State Bar of New Mexico administers that program, and what they do is they enter into a contract with the providing bank, and one of the things that the contract says is, you bank will notify the Office of Disciplinary Counsel if a lawyer presents a check against their trust account that won't clear. Whether you pay it or not, if there's not sufficient funds in that account to make that check good, right, the bank has to go ahead and let it overdraw, they have to notify our office of insufficient funds, right? So they'll send us what we call an NSF notice, which is probably what you call it, and they'll charge you a nice $35 or $50 fee, whether they pay your check or not, right? And so what happens is we will get that, and I will write you a letter, and I will ask, why are you bouncing checks or trying to bounce checks if they paid it? What's going on with your trust account? And what I'll wait for is a response from you, and I get a variety of responses, some that are more troubling than others, right? So on the less troubling side is the bank made a mistake, and the banks do periodically make mistakes. They deposited it to the wrong account. Whoever was doing their proof machine transposed some numbers. Whatever happened, it went the wrong place. And you didn't know it, and that's not on you, that's on the bank. Let me suggest to you that when I send you that letter, I'm going to expect you to respond. And if your response is the bank made a mistake, then I'm going to write you another letter and say, really? So prove it. And all that means is have the bank send me something. Save yourself the step. Right? If you get a letter from me that says, why are you bouncing checks on your trust account, and you know it's a bank error, I'll usually give you a week to 2 weeks to respond. Go to the bank, get the letter, and send it all back at once. We'll save a step. But if it's on the bank, truly on the bank and not on you, that's normally the end of it. Yes, sir.
Well, I had a banker situation like that. What helped me was I had the letter to the old folks before they even knew what was going on.
So he had a bank error, which resulted in an overdraft or a potential overdraft, and he actually proactively fixed it before you even got the letter from us. Right. Great. And that's fine. I'm happy for that because the bank will normally notify you too. If you want to preempt my letter and send me everything and say, hey, you're going to hear about this, let me tell you what happened, that's fine. That's actually good. I like that. Sometimes we'll get a response that, whoops, I grabbed the wrong check. There's nothing inappropriate with using the same bank for your trust account and your operating account. In fact, it's convenient. People do it all the time. If you're going to do that, there's a couple things that you should do. So first thing you should do is make sure that check stock, meaning the stuff that it's printed on, should be vastly different between your trust and your operating account. Get bigger checks for one, get, like flaming red or pink. Put that trust account check somewhere far away so that you have to really make a very conscious effort to go grab a trust account check. The lawyers who tend to send me that response, they've got their checkbooks both sitting in the same drawer on the left-hand side of their desk, and they reach down and pull out a check and write it, and then they send it, and then, whoops, I used the wrong check. All other things being equal, the first time that happens, maybe I'm not going to get too worked up about it, maybe. Depends on other circumstances. If it happens more than once, I'm going to ask you to see your trust records, because that doesn't feel like just a whoops mistake at that point. It starts feeling like an excuse. And it might not be. It might be you just did it twice. Then we need to talk about how we fix that. At a minimum, you're going to get a letter from me telling you what I just told you. Start using different check stock, put them in different places, and if you can't do this, go open it at a different bank so that it really is obvious to you, right? And then sometimes we get two other responses. Some of you do personal injury work, yeah? And so in personal injury work, if you do that, especially if you do it on the plaintiff's side, sometimes insurance companies or county governments or city governments will send you a check, right? And sometimes it's a big check if you're having a good day, right? And what's in that check is client money and usually your fee, because if you're doing it on a contingency, your fee is wrapped in there. And then if it's personal injury, a lot of times there's third-party providers like medical providers that maybe you've given letters of protection to. All of that comes in one check made payable to you and the client. So where does that go in the first instance? It's got to go to trust, right? Anytime you've got client or third-party money that's tangled up with lawyer money in a single check, that goes to IOLTA first, and then you distribute from IOLTA. That's not commingling. That's an expectation that the client money is dragging your funds into the trust account to be distributed in a reasonable time. The second thing that happens, though, if it's a big enough check, is the bank will say to you, what? What does the bank say to you? $300,000, maybe you have a really good relationship with your bank, but if you get a $500,000 check, is the bank going to give you immediate credit? Some banks will if they have a good relationship with you. Most banks will not, right? Most banks are going to put what's called a hold. And what does that mean? If there's a hold on the $500,000, how much of that is available to you? Nothing, right? And yet what happens, and this is what we hear sometimes from lawyers, is I notified my client that the settlement check was in. And actually 16115 does say that when you receive money on behalf of the client, you need to notify him, right? And so what does the client do? The client rushes down to the office. I need my money. And you know there's going to be a 5-day hold on it. So today is December 7th, and you know that they're not going to release it in 5 banking days until December 14th. And lawyers will sometimes be tempted, which they shouldn't, but they will be tempted to do one of two things. They'll go ahead and write the check today and hope for the best. That's never going to work out, right? Or they will say to the client, you can't cash this till next Friday. So I'm going to date it December 15th. You promise? And the client says, I promise. And then the client walks out, and across the street is Bank of America or Wells Fargo or whatever bank you want, and they beeline it for it, and the person at the teller window doesn't pay attention to post dates, and the check gets presented and tendered, and then it doesn't clear because that money's not there yet. The bank hasn't released it. that's going to be a more serious conversation with our office, because you're writing checks against money you don't have. At a minimum, if I understand banking laws correctly, there's a problem with post-dating checks. It also could be viewed as deceptive conduct under the rules of professional conduct, right? So don't post-date your checks. Just tell the client, I've got your money, but it's not going to actually be available to you for a week. So don't come driving down here because I can't give it to you, right? And then the last thing that sometimes the more common things we hear is one that I heard recently, which is, oh, my bad, I wrote the same check twice. And sometimes we get the image checks, but not often, right? And so then I write back and say, well, okay, that's nice to know you wrote the same check twice. Tell me a little more. Who did you write the check for, and what was the purpose? And the response I got in that case was, well, I wrote the check to the Public Service Company of New Mexico. For, what do you think it was for? For what? For $43, but for what purpose? To pay my light bill, right? Out of my trust account. Is that proper? No, right? Trust account, the money that comes out of trust account basically should be coming out for one of two reasons, right? It's coming out for legitimate client expense. Now, I know now that filing in state court, you actually have to use, what, a card? So you use the card, which means you're basically advancing it, and then you take it out of trust and put it in your operating. That's fine. But, you know, maybe you're paying an expert out of trust. That can come out of trust directly. That's a trust check. Right? And then sometimes you're going to earn fees, and then you transfer from trust to operating. That's legitimate. On occasion, we see lawyers who decide that they can use their trust account as a de facto savings account, and they'll keep track, they say, in their head, or sometimes even on paper, of how much of their money's in there and how much of the client's money is in there. And when they have an expense and they know they have their money in there, they write straight out of trust. You cannot do that, right? That's a violation of the rules. It's a violation on a couple fronts. One, you can't write money straight out of trust. Two, it's a huge commingling problem, right? Because you're leaving lawyer money in the trust account. Now, I had somebody early on when I was doing this presentation ask me, well, what's the big deal with commingling? It's just because you're pedantic rule followers, and that's why you get upset about this. Not at all. Well, maybe we are, but that's not really the issue, right? There's three reasons I would tell you that I think it's a big deal when lawyers are commingling funds. Right? The first one, what do you think the first one might be? Why do you think I care that lawyers are keeping their money and their clients' money together?
It makes it pretty difficult for you to do your job, I imagine.
It can, but, you know, that's what they pay us the big bucks for. Yeah.
Basically, it's theft. You're not supposed to be borrowing your client's
right.
money or using your client's money in any way.
Right. And that's basically right? You've got your money and your client's money together. The more you do that, the more you start using your client's money like your money. And in fact, I can tell you that that happens on occasion. When we recently had a lawyer who had a very robust trust account and a very difficult time on occasion on the cash flow side for the business. And so we got trust records, and the trust records were actually pretty good trust records. Good general ledgers, good client ledgers, good reconciliations, bank statements, everything you would want to see. And then we also found some promissory notes in the trust records. And the promissory note was from lawyer to lawyer's trust account. And then there actually even were some collateralization documents. Right? And what the lawyer was doing is exactly what this gentleman said. Borrowing from the trust account when cash flow was tight and then paying it back when cash was flush. That's called stealing, right, in our view. You can't use it as a line of credit. So that's the first problem, is that comfort level with now I'm using client money for my money. Second thing is, think about what it is. Interest on lawyer trust account, right? Trust being the key word. Those of you who do any kind of work where you have creditors or debtors' rights, money in trust is normally what? Is it reachable by creditors? In a lawyer trust account, it shouldn't be. So if there's something untoward happens to you, a contract dispute with your landlord, and they get a judgment and now they're trying to enforce it, in theory, they can't reach your trust account because that's your client money, not your money. And so there's at least a concern or a perception that maybe you're trying to hide assets if you're commingling, right? And then the last one is the 7-year itch, right? Who else cares about, well, let me phrase it this other way. When you earn trust money now becomes earned fees, where does that money go? It goes to operating, right? When it hits your operating account, what do accountants call that? Income. And when you have income, what does the IRS want? They want money from taxes, right? If you're leaving money in the trust account, that's a view of, or at least a concern that maybe what you're doing is you're trying to shelter or completely avoid tax liability. And that's a problem for the IRS. So there's plenty of reasons not to commingle, right? Now, I've heard, and if this is the case with you, tell me, or better yet, tell the state bar. Some banks are saying, well, if you don't have an activity on your trust account at least once every 6 months or once a year, we're going to close your trust account. They shouldn't. If they tell you that, okay, and usually what they're going to tell you is we need you to run $25 through it. And sometimes they'll tell you that on opening. If you take and put $25 in there and then wash it right out so that the bank doesn't bust your chops, nobody's going to get terribly worked up in the Office of Disciplinary Counsel about that, but we would like you to tell us so we can try to tell the bank that that's not how it should work. You should be able to have your account at zero forever with no activity, and the bank should not be trying to close it on you. If you have to take intermediate steps to make that happen so that they don't, I get that, but it should be de minimis, and you should be able to document it, including the bank, in writing telling you that's what you have to do. Now, how much can you leave in, though, in your trust account of your own money as a cushion? Because what happens is sometimes lawyers will tell us, I know how I'll avoid this overdraft problem. I'll leave in $500 or less. All right, based on what I just told you, that gave this away, right? None. As a cushion, you can leave none. Now, you can deposit into the bank account that amount necessary to offset actual charges, but that's going to be pretty simple stuff like charged for check fee. And usually you can ask them to take that out of your operating account. Or if any of you take credit cards, for retainers? Prepayment, right? No? If not, that's fine. If you decide to, make sure that the vendor charges your vendor fee, because they usually charge you a convenience fee of 2 or 3%. That should charge to your operating account, not your trust account. And if there's a dispute with the credit card, that chargeback should go to operating, not to trust. Right? So the only thing that should ever show up in your bank account of your money would be if you deposit just a minimal amount when the bank tells you they're going to charge you, and you should know exactly what that is. Ask the banker, right? But as a cushion, you should leave none in there. Yes, sir. And then
I got one of those letters from you.
Did you?
Yeah, it happened. I never have any money in my trust account.
Right.
I got a retainer for $1,500. I put it in there. It bounced. The check bounced from my client.
Right.
The bank charged me a $35 overdraft.
Right.
There was no money in there.
Right.
The overdraft fee.
So now it's minus 35. And then I write you this hateful letter.
So why can't I keep a few bucks in there just
Right.
to make sure something like that doesn't happen?
Right. Well, so first off, I mean, how do you know what a few bucks would be, especially when you have a client who's going to bounce a check on you? And second off, once the 35 hits, obviously we're going to say go ahead and deposit the money to pay that, because that's a necessary maintenance fee for the account, right? That's legitimate. Prospectively keeping it in there, technically the rules don't allow it. If you left $35 in there on the assumption that occasionally somebody's going to bounce a check on you, you may be able to say that that's a necessary maintenance fee. I don't know. It's technically outside compliance with the rule. And the problem is that it starts then leading to at least some attorneys getting more comfortable. Well, if 35 is okay, I'm worried that maybe somebody's going to bounce a big check to me and I'll have written a check against it, so I'm going to leave 100, and I'm going to leave 250, and I'm going to leave 500, and it just escalates. So you should not, is what I'm telling you. I think he had his hand, and then you. Yeah, you. Yep.
I have a trust account in another jurisdiction where I leave 1 cent of my operating funds in that account just so the bank won't close it. If that was a New Mexico account, would that be a problem?
I'm not going to get too worked up about a penny. Technically, you should not, but that sort of de minimis. What probably would happen in New Mexico is probably when IOLTA, because what happens is IOLTA comes through and skims a bad word. They take that money, and they fund access to justice projects, all the interest. Probably what would happen is when the rounding errors come, or not errors, when the rounding comes about, they're going to see that penny and think it's interest and probably scoop it out of there. But here, really, the bank should not require you keep even a penny in. Yes, sir.
So, assuming you provide the client when you withdraw from the trust account both the bill and a statement that shows the balance, can you do that on the same day?
Yeah, good, that's a good question. So when can you actually take your operating fees? I've seen it done two ways. The way you describe is not improper. Make sure you agree to that up front with the client, right? That should be part of the retention agreement, which is, client, I'm going to put your money on deposit in my trust account. At the end of the month, I'm going to bill against that. And what I'm going to do is send you an invoice that will show your starting balance, what I billed and moved to my operating account, which you moved, and then what's left. And then if you and the client get into a beef, you sort that out. The other way that people do it is, I'm going to send you an invoice. I'm going to give you a week or 2 weeks to digest it. Call me if there's a problem, and at the end of that 2 weeks, I'm going to move it. Either way is fine. All right. And I think you got earlier, the IOLTA is not an operating account, so you can't use it as that. Disputed funds, right? So if you and the client get into a beef over some of the money that you think should be moved out of the account for some reason, what has to happen with that? Right? So you send the client a bill, $2,500, and the client says, "I'll pay you $2,000, but not the other $5. I think that $500 is not legitimately earned." What happens to that $500 or the $2,500, right? So it's either A or C. Most of you, or the one of you who's still responding, said A. And A is right. Sometimes we hear lawyers say that they will keep the entire dispute in there. That's right, it's the dispute. And sometimes we hear lawyers say, I'll keep the entire fee or fund or invoiced amount or whatever in there. That's not right. If the client's agreed to pay a portion of it, transfer that. You've earned that. Right? And then the other thing that's sometimes a variant of this is, if you do the work, do all this work in November, you send an invoice out on November 30, the client sends you a check for the work you just billed today on December 7th. Where does that check go? Operating, because it's earned, right? So when you bill after you've done the work, that doesn't have to run through your trust account. That goes right to your operating account. Now, here's where there's a real area for people to get in a dispute with their clients and third parties, right? In every state, I think, but for sure in New Mexico, you can take third-party payment to represent a client. And who's your client? The person who's paying or the person you're representing? The person you're representing, right? They've got to consent to it. You've got to use your independent judgment for them. You've got to make sure that you keep their confidences. But, and let me give you, so dad is paying for daughter's divorce, right? Dad gives you $5,000, that goes in your trust account, and 2 days into it, daughter comes to you and says, "My God, what was I thinking? I love him. We're never going to get divorced. We've totally reconciled. Stop the presses. I don't care what you've done so far." And it turns out, other than the initial meeting that you're going to charge them $400 for, you've done nothing else, right? So what did I say they gave? Mom gave you $5,000? So now you owe somebody $4,600, right? Who are you going to give the $4,600 back to? Dad? Client? If you read 16.115, it says that money held in trust for clients, right? Now there's some discussion about third party, but there's some ambiguity as to who exactly that money has to go back to. 99.9% of the time, dad and daughter are on the same page. Give dad money back. It was a gift, give it to the daughter. I'm so happy they're together again, whatever, right? But you can help avoid that 1% headache of time when they are not on the same page. And you do that in your retainer agreement. If I've taken third-party money, the agreement is, here's who's going to get it back if representation terminates early, or even if it doesn't, if there's just money left at the end of the representation. Right? Because if not, you've got a dispute on your hands. That's going to have to sit in your trust account till the dispute's resolved, and it could mean that you're going to have to file an interpleader because or dad and daughter are fighting over the money, and I don't know who to give it to. Maybe a court's going to have to decide. So now for $4,600, you've spent countless hours and filing fees, and right, save yourself the headache. Put in your fee agreements who gets the money back. You have to have a plan. This is new to the rule. If you don't, it's very simple. Read the rule. It'll tell you what a plan should consist of. If you want a sample or a fill-in-the-blank form, just email me, and I'm in the bar bulletin. Email me, and I'll send you the sample form. It'll take you all of 10 minutes to fill it out. It's got to have the name of the lawyer who signs, or lawyers, name of a responsible lawyer, which is a term of art. And what I mean by that is in the not too distant past, we would sometimes come across a firm that was operating from the outside looking in as a firm. But it turns out they were actually 3 or 4 individuals who had just sort of partnered up to look to the world like a firm, but each of them held their own clients. And although they used a common trust account, each was responsible for their own. Right? So we'd send the bill out and it would say, you know, and Pete would say, well, that's not my client. That's Bill's. And Bill would say, well, that's not my client's, that's Bob's. And Bob would say, well, that's not my client, that's Stan's, right? And so then we play this game of hot potato. So no more. The trust account has to have somebody who's been designated by the operating firm. If it's a solo, that's easy, right? But if you're 5 of you, 10 of you, somebody's going to be responsible for keeping the trust records, including if the firm separates, keeping them for 5 years, and also corresponding with the Office of Disciplinary Counsel and the Client Protection Fund if we request, right? And if we request, they've got to be produced within 10 days. And I won't make you answer the next question, but if they're not produced in 10 days, there's now a specific provision in the rule that considers that an act of non-cooperation with disciplinary counsel or client protection. We will petition the court to administratively suspend you until you start cooperating. And if you don't have them, which I know everybody in this room does, but if you don't have them, much better to just tell us I don't have them and then let us figure out what that means. I mean, again, I'll go back to what I told you earlier. It's not that frequent that we find people truly stealing or commingling. What's more common is we find that they're a little sloppy in their records. Yeah?
So if you're solo, you don't need a plan?
If you're solo, you still need a plan. Yeah. It's just a really easy plan. I sign on it. I'm the responsible party. You'll keep the records, and that's it.
Is a plan something that you just keep in your file?
The plan is something that you'll... Yeah, no, the plan is something you'll keep in your file. At the end of the year, when you certify you're in compliance with trust accounting rules, the education, all of that stuff, it'll be included in there in next year's due statement. And if there is an inquiry into your trust account, what we'll ask for in addition to your trust records is show us your trust plan. So it's going to be a show us if we need to see it, as opposed to send it to me or send it to the bar. Yeah. It's really, email me and you'll be able, I'm not kidding, you'll be able to fill it out in less than 5 minutes. Yeah, and it's a fill-in-the-blank form that I've got for you if you need it. If you want something more elaborate, I can show you something that's, somebody sent me that's really elaborate. It doesn't necessarily have to be. Mostly we want to make sure we know who we can talk to and deal with. Right? Who can sign on a lawyer's trust account? This is a change in the rule that is a significant change, which I think maybe people already thought, but for me it was a significant change. Because in the past, it was not right? That's what it is now. But in the past, the rule said you can have a non-lawyer sign on the account, right? And a lot of people did that. Legal assistant, spouse, their accountant, whomever, right? No more. If you have anybody on your account who's not a New Mexico licensed lawyer, kick them off, right? Go to the bank and kick them off. All right, and you have to reconcile monthly, and I won't make you tell me, I'll show you what a reconciliation looks like, because we're about out of time, right? And you have to take a trust accounting class once every 3 years. You won't have to do the math, right? Because we're not going to have time for you to do the math. It's in the materials, but here's what it is. So you get $5,000 from Mr. Adams or Ms. Adams, pay $100 in filing fee. How much should be in your trust account now? How much? Wait, so you are doing the math. Look, $4,900, right? And then you get $2,000 more from Client Brown. Now how much is in your account? $6,900. So if you had a general ledger and you stopped right now, you'd have $6,900 in the general ledger. In Adams, you'd have $4,900. That'd be in the individual ledger. And in Brown, you'd have $2,000 in the individual ledger. That adds up to $6,900, right? Those two numbers match, which is what you want. Right? And then you go along and you have some other transactions. And here's what a general ledger looks like. You can see that if we stopped where we talked about earlier, that was the $6,900. There were a few more transactions in there, ended up with a balance of $5,400 at the end of the day. Yes?
So I use time slips and enter the information for each client.
Right?
And it keeps track of payments.
Great.
Keeps track of disbursements, all of that.
Great.
You're not saying you have to physically have separate ledgers for each of these people. Time slips is okay.
If you're using a program that has built into it a ledger type function that's going to keep track of all those people in a form you can print, that's fine. Yeah. You've got to have a general ledger. You've got to have some way where you can demonstrate the individual amounts held for each client, and that's a ledger in some fashion. Time slips will do it. If you don't have a very active trust account, we have a trust account at the Office of Disciplinary Counsel. When a lawyer from suspension is applying for reinstatement, they have to deposit $1,500 to go against the reinstatement costs. Sometimes lawyers die, and we end up having to take their trust account and try to distribute it depending upon who it's owed. That all goes in our trust account. So we actually have to comply with the trust account rules and take this class, right, which I have. We use QuickBooks. That's not to endorse QuickBooks, but it's a pretty simple program that almost anybody can use. So if your trust account is not that active, you can use QuickBooks. You can do it by hand if you want to. I don't care, as long as you're getting the necessary elements, right? Now, $5,400 at the end of the day in your general ledger. I would tell you if you added up your client ledgers, there was $400 at the end for Brown and $400 for Adams, $5,000 for Brown. That's also $5,400. And then reconciliation. Three-way reconciliation means this. Three-way reconciliation, which I'm sorry, that's blurry. Here's what you're doing. You have three numbers, and they all should be the same. So you're going to get a bank statement every month, and you have to reconcile every month. What's going to happen is your general ledger should be the easy number, right? Because you're keeping a running balance, $5,400. Your client ledger should be relatively easy. If you went to the store today and you bought $2.50 worth of soda and you gave the cashier a 10, how much would you get back? $7.50. If you can do that, you can add up client ledgers, right? If you add up client ledgers, that should be the same as your general ledger. Then you take your bank statement and you just adjust it. And the way you adjust it is you add back any deposits you've made since the bank statement cut, right? Add to it. And then take any checks that haven't cleared and subtract those. And that should be the same number. So in this case, the bank balance was $7,900. There was a check for $2,500 that didn't clear. $7,900 minus $2,500 is $54,000. $5,400 is the same number as your general ledger and your two client ledgers. All right? That's simple. And with that, I'm happy to stick around and answer questions, but I think we're at the hour. And you've now come into compliance for 3 years, right? Good for you guys.
Thank you to Bill, and congratulations to all of you on that grand achievement. We are done for the day. And please do remember, if you're not coming back tomorrow, to leave us your evaluation form, but even more important to you, do fill out your form for your CLEs. There's a box out front. We'll collect them. Please leave both forms if you're not coming back tomorrow. If you are, you can do it tomorrow.
I really hadn't thought about it until you were talking about all this stuff. When I filed through Odyssey,